Hello and welcome back to Trial TV Live. I am the Squeegee of Justice. Thanks for coming back and joining us. We lost power there for a brief moment, so let's get back to our deep dive of Florida versus Shanna Gardner and Mario Fernandez.
Good morning. Give them just a moment. Is the Zoom situated?
Yes, ma'am. Yes,
okay. All right. Ready?
Good morning, Your Honor.
Good morning.
Christina Stifler and Mark Khalil on behalf of the state. We're ready to address number 2 on the court's calendar, Mario Fernandez-Saldana. Number 5, Shanna Gardner.
Okay. Good morning.
Good morning, Your Honor. Patrick Purdy on behalf of Ms. Gardner, Mr. Baez, and Ms. Peoples are present via Zoom.
Thank you. Good morning.
Your Honor, Shannon Davis.
Good morning.
On behalf of Mr. Fernandez with Frank Tassoni.
Good morning. So we're here on several motions and also a case management hearing, and I'm interested in y'all's thoughts, but what I thought we could do is, I think it would help in some of the motions that the defense has filed, is to give me understanding of where we're at as far as the discovery, what you all have.
Judge,
Unless there's something that's come up since the time of the filings.
Judge, it's our position on behalf of Ms. Gardner, based on the letter sent by Mr. Khalil, that we are at an all-stop.
A letter.
Yes, it was enclosed to Ms. Day's motion that she filed.
The one about the reorganization?
Yes, Your Honor.
And a new drive, that we are at an all-stop, Judge. We have made several requests for things that we believe are outstanding. We were supposed to have a deposition
Of
we thought,
the detective?
Johns, to sort of go over, like,
Why don't, hold on, okay. Let's, why don't y'all have a seat, okay? Mr. Khalil, you can be seated. We're gonna settle down. I need to use a microphone. What is the state's proposal?
Your Honor, after discussion...
You can use them, give him a desk microphone. Okay.
Your Honor, after discussions with counsel and then the state's team, we decided that it would be best that we reorganize. There seemed to have been some confusion as to what exhibits have been tendered, what has been tendered in what format. And so the letter that we sent to counsel was notifying them of our intent to assist the best that we can. We are going to index the discovery that has been previously tendered in all of the prior discovery pleadings, so that everybody would be working off the same sheet of music. That when we were referring to a particular exhibit and a file and the file size and everything, that everybody would have the same understanding. That we are in the process of going through and completing that indexing. My proposal, because I had done it in previous cases where we've had voluminous discovery, is to then provide hard drives with the index and all the materials in the format that are discussed in the index to both counsels, and then also file an exhibit with the court. So even the court, when we're arguing motion hearings, would have the same index and have the same materials that would be available for discussions during the course of the motions. It was our understanding, after offline and off-record communications with counsel, that this would be of assistance to everybody. The other requests that we had made, because Ms. Stifler was getting requests from multiple parties from both defendants' teams, and then also even receiving communications from defense experts about formats that are being received and things of that nature, that we figured it would be better to create, one, an email box. There was an error in the creation of it, but we've now cured that error. an email box for communications, and then also points of contact so that we weren't responding to multiple people on multiple sides, so that we would bring some sense of order the best we could. Everybody understands that this is voluminous discovery. This was a suggestion and a proposal that we thought would be the best way to sort of try to bring some organization to it, and we're working towards that effort to do that. And we felt that after discussions with counsel, would be beneficial to both teams, to the state and to the court moving forward, so that everybody was a little bit more organized. This is obviously a very discovery-intensive case.
Was that the defense proposal? You can be
Yeah,
seated.
no, Your Honor.
Use the microphone.
No, Your Honor. Well, and in fact, the first time I heard about it was when Mr. Khalil called me to told me that that's the way that they were moving forward. Because from Ms. Gardner's position, it was not. We have concerns. We have spent hundreds of hours going through what's been turned over, and we have complained about both the organization of the discovery, the file titling of the discovery, the duplicative disclosures, the vagueness in the discovery exhibits, and now seemingly we are going to have to go through every single thing again to make sure that what the state now proposes is the version we will use for trial is exactly what we've already reviewed. And there is no way for us to do that without opening up each file and confirming things like the page numbers match, that they are the same files. I mean, Judge, we don't know what we don't have, and we've voiced that several times. We've gotten different files that appear to be the same that are not. And I under the law, we have a right to have the discovery, but the manner has been so disorganized with a lack of clarity, as was even pointed out at the last status conference, and what they are turning over, you know, that we're frustrated, Judge. Frankly, we're frustrated. I mean, this is going to delay the trial. There's no other way about it. It's going to increase the man hours that our defense teams, which are privately retained, have to expend just to make sure we know what we have. And it's, you know, the word I would use is frustrating, Judge. It's simply frustrating.
And I see Ms. Day. Ms. Day, you're the contact person for Fernandez, correct? And you're the one that's been going through the discovery, correct?
Yes, Your Honor, and I would echo everything Mr. Carodi just said.
Are you using the microphone? For the benefit of Zoom, you have to use the microphone.
I think so.
Okay.
Maybe. The only thing I would add is we've tried this before. Both our firm and Mr. Carodi's firm have previously been provided externals that we were told contained everything that the state had. We have meticulously reviewed the externals, provided list of things that were missing, and then we were told next point was coming, everything would be on next point, and all will be well and good. We got next point, within 2 weeks it was shut down. Then we went back to the externals. Once again, we're told everything will be on there, all will be well and good, just be patient. We get the externals, we do the exact same thing all over again. Then we're told evidence.com will fix everything, just be patient, we'll upload it. Once again, we review thousands of documents, and we're still requesting the same missing discovery that we've been missing since last May.
Mr. Khalil, I know that you are like maybe coming in and offering this as a solution. Sitting in the same position, I don't think it is. I really just don't think it is. So I have printed off, and like, when I printed off all the state's disclosures, okay, I've printed off the specific demands. I have tried to, just in so I could try to get some type of understanding, lining it up, and it just doesn't. And the same thing that the defense is saying has been the same thing that this has been communicated with the court. I believe the parties can correct me if I'm wrong. I tried to conduct a case management hearing, maybe, y'all correct me, like around December-ish, okay, right before kind of holiday break, and I was told something similar, that hard drives would come in, and I don't necessarily think a hard drive will fix this problem, because I think we're on hard drive number 3, we're on cloud service number 2, and y'all can correct me, I think the defense is objecting to evidence.com because something was inadvertently uploaded yet again.
Ms. Gardner's devices were uploaded.
Ms. Day informed me that she obtained an unredacted copy of one of Ms. Gardner's cell phones that contains attorney-client communications.
It's not going to fix it. So, to facilitate what did y'all do with the hard drives that have previously been given to you? You're just keeping them and you're comparing the two?
Judge, it is so voluminous that most of the stuff we have gotten onto our own cloud service, but that's no more than a file share service. And that is at least what Ms. Gardner has done, so that we can share it amongst our team, but we...
So you're taking the hard drive that the state has given you and you're uploading it to your own file share service, but so you have now 2 separate kind of electronic...
We have hard drives, and then we have working copies, I would say, on the cloud that people can access and review.
Okay. And forgive me, y'all have to be patient with me because I don't know / I'm trying to get some type of understanding, okay? So on the hard drive, and I'm gleaning this from a complete overview of what y'all are bringing to the court's attention through motion, and also I'm trying to get an understanding from the state's disclosure, all right? So when you all get the hard drives, how does it correspond to what is in writing by the state?
So, and Ms. Day may be better situated to answer.
Well, I'll let her.
Yeah, but...
I'll let her take the lead because she's, let Ms. Day.
Yes.
Your Honor, the short answer is it doesn't.
At all?
No. And I have my external, and I'm happy to provide it for the court to review if the court would like.
Which one?
I have our firm's external, but I have a folder on the external in which I've saved every evidence.com as it was received.
Okay, so let's start with the first one, okay?
And when you say first one, Judge?
The first disclosure, there's one that was filed on November 15th.
In Ms.
2023. It has both defendants. This is when the joint indictment at or around that time. So if y'all pull it up, November 15th. So on that particular exhibit, I counted 85 witnesses, category A. Then it is referenced, like the different subparagraphs, right? And then there is a Brady disclosure on that particular document. And to my knowledge, while it was written by Mr. Tassoni that the sixth supplement had Brady information in it, but it was not disclosed Brady, right? The sixth supplement. It was just the notes. Are you with me? The notes from Mr. Chipperfield, but it was not disclosed under a Brady paragraph.
Correct.
But the defense,
That was just the transcript, Judge. The notes came, I may be confused fifth or sixth, but the first disclosure regarding Tenon was just,
no. I'm on the sixth where they give over
oh, yes.
Chipperfield's,
I understand. Yes, Judge.
okay, but it was not identified as Brady.
Yeah, yes, Judge.
It was just notes.
Yes, Judge.
But what I'm referring to is the writing by Mr. Tassoni, who indicates the defense position is it should have been or is Brady,
Yes, Your Honor.
right? But there's only, what I'm asking, okay, is there's only one Brady disclosure that I'm able to see from the state of Florida, and it is contained within November 15th, right?
Yes, Judge.
I'm still on November 15th, but I'm comparing back. There is a writing by Mr. Tassoni that there was a reference to Tenon's jail calls in this November 15th disclosure, but I could not find it. It is the subject of Mr. Fernandez's specific discovery request. Where is it in the state's disclosure that they had Tenon's jail calls?
If I remember the disclosures correctly, I don't believe the state's discovery exhibit specifically identified any defendant's jail calls individually. I think it was just listed as jail calls.
Where? Pull it up, Ms. Day. Or the state can pull it up. Because that's one of the things that y'all wrote that you've been asking for essentially since the beginning.
And Your Honor, which pleading are you referring to the last pleading of Mr. Tassoni that was filed 2
Yes.
days ago? Your Honor, the state would request, we just received the pleading, and we would request time to respond in writing. I think that would assist in clarifying this. We're not prepared to address all the issues in that motion today.
Okay, I will set aside a different time. Today, I don't necessarily have to hear the motions for sanctions. Today, I can set aside that time. Today, I want to get a full understanding of what just is before y'all start coming up with solutions. And Mr. Khalil, what I'm trying to explain is that this court feels as though if I don't, and then the state then proposes another solution, okay? This is how this case has been going, okay? Which there have been issues brought to this court's attention. I have a relatively short pretrial where everyone says, we have a solution. Then I pass this case off weeks and weeks and weeks, okay, for y'all to get together, for y'all to talk, for y'all to do this, and then what comes of that is more motions, more misunderstandings, more violations of the court's orders, okay? And so my thought is, it may be like, I don't mean to be as methodical, but I've never sat down with y'all. I've never really done this on the record. Every time I ask questions, and I'll give you an example, Ms. Day, if you recall, we were at sidebar, and I thought, I believe it was at the last court date, the state thought that the defense had a searchable a device from the Secret Service. Apparently, the state has the ability, with whatever format they have, that they can search, the defense can't. And then you explained to me that what you all were given is if you click on a document, it's a zip file, it takes X amount of time to unzip it, you wait 3 minutes, you wait 20 minutes, you wait 2 hours for it to unzip, and then when you get it, it's some random search on the internet that has nothing to do with anything, and it's a waste of time.
It takes us days to download and unzip the files, and oftentimes we open them and it just appears to be computer coding.
That's what's going on. So the state thinks that you're giving something usable, and it's not usable. You take issue with that, Ms. Stifler?
I think some of the issues Ms. Day has brought to my attention at least have been somewhat user error. So some of her requests that I got,
Use the microphone.
some of these requests I've gotten in her most recent, or the letter that I've responded, they have sent me lists via email. I have responded via email, and in the state's first supplemental demand, in an italicized portion of that demand, I responded to their list. Some of the issues she's raised to me, we've discussed at a discovery conference at our office. Some of the platforms of the information for downloads through Axon or Axiom for the computers are HTML based. So if she opens it, the report goes through a web browser. That's just how it works. That's one clarification I wanted to make. As far as the extractions, we've provided to defense counsel our UFDR files, which they can open through Cellbrite. They also requested the raw data, which I made available to Ms. Day to go to Secret Service and get the raw data for her client. For Bias Firm, their expert has been contacting me directly, requesting new copies, first original copies, various formats of different data, and I've complied as best I can to give him what he needs. We have our expert, who is referenced in the letter Mr. Khalil sent, who's going to coordinate with Bias Firm expert, and if Dreiser Hill has an expert as well, to get them the digital data in the formats that they're requesting. So part of it is they're asking me, they're using terms with me like raw data, and I'm giving them what I believe they're asking for. My expert is gathering all these things in one place on all the devices to give it to them in whatever format that they're actually requiring. So they have both the readable version through Cellbrite and the raw data itself. I don't know which one she's looking at. It sounds like she's looking at the raw data, if that's how it's opening. But we've provided multiple versions in different formats for these things several times.
When you say raw data, you mean like metadata behind whatever might be, not metadata?
Not metadata.
Okay.
So when you do a forensic extraction on a cellular device or computer, you're copying the information on the phone and decrypting it. You have to parse that data through a software program. For example, a phone, you would use Cellbrite. For a computer information system, in a car, you would use Ivy. You would use Axiom for a computer. So when we provide that to them, we give them the reader. We would give them Cellbrite on the phone extraction so that they can pull the parsed data through Cellbrite, open it, and read it the way you would a regular phone download. Their experts and their firms have also requested the raw data. I presume, and I don't know, that their expert perhaps has some sort of forensic equipment or a physical analyzer that they want to parse the data themselves and make sure it matches up to what we've parsed. So the example that we've been given from Cellbrite is you have flour, eggs, sugar, you have cake batter, and you have a cake. We've provided them the cake, which is the finalized PDF reports. We've provided them the cake batter, which is the UFDR file, so you can run through Cellbrite. And we've provided them the ingredients, which is the raw data.
All right. How are you?
I'm going to respectfully disagree with Ms. Stifler, and I also want to point out for the court that our digital forensics expert had a flight down here on February 25th. He had confirmed the date with Ms. Stifler by email on February 10th, I have the email if the court wants to see it, Ms. Stifler indicated that she would be in trial, but someone from the state can be present. I will have Detective Ostertag reach out to Mr. Green directly, our forensics expert. Detective Ostertag never reached out. Mr. Green was prepared, and it was canceled because the state was unprepared for the meeting on February 25th that they agreed to. So, I mean, this is, and our expert has looked at what Ms. Stifler has provided via evidence.com and said, that is not what we're asking for. And so the solution was that at our expense, right, we were going to fly our expert in to meet with the state to literally look at it in person, perform whatever methods he needed to perform, and the state canceled. So I think this idea that they're doing everything they can and making sure we get everything we've asked for is not true.
Okay.
The meeting did not happen. I did not cancel it. Mr. Green canceled it because he said he had not heard from Detective Ostertag. I reached out to Detective Ostertag and Detective Johns to reach out to Mr. Green, but Mr. Green said he was just going to go ahead and cancel.
That was the day before, Judge, because no one had reached out to him. He wasn't going to get on a plane without being confirmed that he was going to have a fruitful visit here. No one had reached out to Mr. Green after the meeting was confirmed on February 10th. And I've got an email from Mr. Green, bringing this to the state's attention on February 24th that no one has reached out.
So the defense is saying that whatever has been provided, you cannot use it for your defense preparation. I've not looked at it specifically, Judge, because that's why we have an expert, but our expert has told us that is not what we want. Okay.
And Your Honor, I would just add, while we have received several copies of certain devices, oftentimes the file sizes are completely different. So we have no idea if there was a download error, if there are different versions of reports or downloads. We have no confidence that the versions we have are full and complete. We're just wasting our time reviewing incomplete documents that we're going to have to completely redo.
And you're talking about from the point in time that I'm at, which is November 15, 2023. You have no confidence that these things are complete.
For instance, Mr. Tennant has several cell phones. One of them I've gotten 4 or 5 copies of, and all the reports are different sizes. Ms. Jensen's cell phone, I've also gotten 5 different versions of. All of those reports are different sizes. So, and these reports, they're 100 gigabyte reports, they're massive. So to spend time reviewing all of them separately.
What is the explanation of that?
Because we provided them via evidence.com, our next point. If they're down, again, it could be on the user end. If they're downloading it and their computer's running another task, there could be skipping in the data as they download it or an interruption in the download. So I have my forensic expert. He's going to go to the original extractions, rehash all the values, provide the hash values, which is the file size for each original download that's in the possession of the custodian, the original devices, and provide that to defense. We met with him yesterday to get that completed. And Your Honor, just for the court's information, the indexing that we're describing, I have listed these items and provided them. It is not intentional on the part of the state. It is, obviously there's voluminous discovery. I've been attempting to provide them what they're missing. There's difficulty with them receiving things through cloud-based downloads or for transferring. And Ms. Day, and I'm not faulting anybody, but we have sat together multiple times and transferred things from her laptop to my laptop. Neither one of us can control the computer processing and perfection of the download.
I understand. I'm not having any hearing on sanctions. What I'm trying to get to is, so the state is proposing something, right?
Yes,
That you
And
re-index.
I'm going to clarify one thing that Mr. Khalil said. The thought process behind the index, and for defense counsel's information as well, and I spoke with Ms. Day about this. I'm not intending to re-provide them all this discovery and say start from scratch. The idea behind the indexing would be that I provide them a number for each exhibit, which would be our working number for trial for our exhibit list, so that that number stays consistent throughout the entirety of litigation up and through trial. So we're all clear what we're talking about. That number corresponds to the name and a sufficient description of that piece of evidence, and that we tag it where it is on evidence.com, what file name it's under, where they can find it, and where it's been previously disclosed in the state's supplementals and original discovery exhibit. So I just want the court to kind of understand the thought process behind the state. It's not giving them a whole new hard drive and indexing it. It's an index of what we've already provided, hopefully to be a roadmap that they can look at. Exhibit 643 is Henry Tennant's phone. It was listed in State's Exhibit 1 on page 4. It has been provided on evidence.com under subfolder subpoena search warrant returns, titled as this, audit trail showing it was downloaded by defense on this date.
Can I stop you for just a moment?
Yes, ma'am.
So in listening to what they're saying, because the state has provided multiple copies of potentially the same thing, and they're, I guess, concerned that whatever they have is not what the state has / what the state would use, how would that then solve the problem? Additionally, how would that, because from what you all have been telling me, okay, what I'm understanding is that the state has not tagged every single file / thing that they have gotten, and you've been kind of doing it via email or whatever. And then how would you document a second, fast forward, fifth version of whatever they have?
So the evidence.com has an audit trail, which is, and obviously I've sent some things via the portal, which has an electronic trail of what they've received. The responses to their emails and letters have been by email, which I asked Ms. Day in the letter she attached to her filing, or Mr. Tassoni's filing. There's a letter with outstanding discovery. I asked her to number it so that I could reply via letter in numerical sequence as well, saying, you know, say number 1 was the HTML issue. I can't get this computer to open it, tries to open a web browser every time I click on it. I would respond, 1, Axiom is a web-based application. It will open a file through a web browser. Item 2, we are missing X subpoena. The subpoena is in the Jack's Beach Police Department Supplemental Report 5 attached. So that's how I was planning on responding to her letter. The indexing, the way that we've organized the discovery on evidence.com is in subfolders. So it's organized under a tag of subpoena. It will have a subpoena and the subpoena return.
Judge, we've never seen that. It comes in similar to the screenshot that Ms. Day attached, where it's just files with a series of numbers and...
Hold on, let me get there, okay?
Yes, Judge. Like page 16 of 109 in Ms. Day's motion.
And that's what Mr. Dreiser attached about that transcript.
Yes, Judge. They're unlabeled. They're just numbers.
Is that not how it looks for the state?
It's not how it looks for me, but I cannot change the file names of these documents. Some of
Right,
these
but-
electronic documents, because that would be changing
Hold
the
on,
original name.
pause
of the
for
file.
just one moment. So this screenshot, and I'm looking at 16, Exhibit C, okay? Now I'm looking at 16 and 17. So let's start at 16. It has a series of file folders, right? And then it has a bunch of like various file types and MP4, which I'm assuming is some type of audio, and then a bunch of PDFs.
Yep, and if we want to know what that is, right? We have to open it, determine what it is.
And sometimes the opening, that's what you're saying, is it a zip or unzip? Like,
We download it as a zip. We have to extract it. When we extract it, this is what it looks like. And then, for example, if I want to know what 2024-1031-103_104-282-212-7, I have to open that. I determine what it is. I then have to do a save as, create, if I want to remember, like if I want to find this at a later date, right? I have to do a save as, save a duplicate copy in my own files that this is the transcript of the January 13th 10 in court hearing.
okay,
Because there's no way for me to correlate this to what the state is turning over unless I open it up, review it, and save it under a different name.
okay, pause. Now, so let's say, Ms. Stifler, look at page 16. On page 16, how does that look to the state of Florida on your end of evidence.com?
The files are categorized in subfiles: subpoena, search warrant,
So
interviews.
they don't have these numbers.
I'm not sure. It's the same way on the CIP when we send discovery through.
I don't know what CIP means.
It's the portal that we use in most cases through the clerk's office. So
Okay.
they sign up for e-service, we go through it. I have no control over how the specific programming titles things when they're sending them.
Okay, go back.
Yes, ma'am.
Is that how it looks to you? Yes or no?
No, ma'am.
Okay. Is there a way for evidence.com for the state to give the defense what you are looking at? Because what y'all solution is not a solution if then you create some index when you're viewing it from the way that you can see it, and then giving it to them, and then when they look at an index, then it's just a bunch of numbers, and then they're back in the same situation. Do you see what I'm saying? Like, if you're not, it's not comparing apples to apples.
And Your Honor, if I may add, I think that was the purpose of the hard drive and the cross-reference index, is understanding, and again, I'm probably not the best person to be talking about digital evidence. I'm a dinosaur, I'm a paper guy. But when we are talking about this digital evidence, it is being transferred not at the fault of the state, but as a fault of the delivery mechanism in a different view.
Understood.
And so that was our goal in having it in the hard drive, so that everybody, when they opened, hypothetically, index number 1, where it's all labeled index number 1 is what we're looking at, so there's not a difference based upon what my evidence.com screen shows and what their evidence.com screen shows. When we open up one, we're all looking at the same document, and we're going to say, when we're looking at that, this is where it was previously tendered under this supplemental discovery response, and this is the data size, how much data, what the size of the file was when it was tendered, and that's the size of the file that it is.
What I'm saying is, I don't think that you're hearing them. So y'all could do that on your end. It does not correspond to what they have been able to see. So you all could go down a line and say, this is on, and you all could say, this is subfolder this, it is referenced in State's Exhibit, filed on such and such date / such and such date. What they are saying, and what y'all are failing to realize, is that they have multiple versions of these things, and so they have been saving them as file XYZ. And so if y'all do that with a new index, with a new hard drive, then that is what they are saying that they have to start all over with, because the mechanism that you all have been using has somehow undone, or whatever y'all are looking at just comes in a bunch of numbers / whatever. And so there's no way for y'all, this index, to truly cross-reference for them to make it easier for them.
I'm going to have to speak to Jack's speech about that. Presumably, I could get, And with the next point, originally, the idea was it was labeled individually, and they couldn't bulk download. They had to download things through subfolders. This gave them the bulk download option, because I was told they need a bulk download option.
But then it comes in numbers.
I understand, Judge. And my point being, I'm not being difficult. I'm trying to adjust to what they're asking for as best I can. I'm trying to provide it in multiple formats as best I can.
Look, we're gonna I want y'all to just strike all this, like, I'm not doing this intentionally, that is not the purpose of this hearing,
Yeah.
okay?
A solution that I might propose, but I have to put a pin in this because this involves giving them access and accounts to evidence.com, which Jacksonville Beach Police uses as their case management system. It would be like us giving them a login to Stack. There's like security clearances, there's issues with that. But if there is a way for me to dupe my evidence.com folder into one and remove access to Jacksonville Beach Police case management system for their entire police department.
Who manages this system? Is Jax Beach or like whatever this web service is?
Evidence.com is how we receive evidence from some law enforcement agencies. They use it as their case management system. I have an account to access this particular case file in their case management system and to share files with defense counsel. I don't have authority to share access to evidence.com with them because it's the Jacksonville Beach Police internal system.
I'm not suggesting that.
My suggestion is perhaps there's some way I can do this by creating a mirror of their files on my account and sharing it with them with limited access so they can't get into Jacksonville Beach Police case management system. Not that I think they would, but obviously they're...
And Judge, if I may just add this one point, and again, using the paper analogy, this is not foreign. If this was a paper case, hypothetically, and we tendered 1,000 documents, and in discovery, which has been done beforehand, how I label my trial file is not going to mirror how Mr. Carodi labels his trial file. I'm going to label my evidence folders or my witness folders or my evidence in the way I organize because that's what I do. Even prosecutors across the board don't use the same organizational system. We are providing the discovery. What's difficult is I don't know how we get everybody to organize their trial files in the same way, and I think that's what everybody's trying to do here.
No, that's not it. So, from one dinosaur to another, okay? When you have a paper discovery, if you gave it over, you would say property card, sequence number, X with 5 pages. So then when you gave that exhibit over, there is no chance of change. So therefore, you, through the state, to me, this paper is the only thing that really matters. Y'all's emails back and forth, you're this and that, and you say, well, Miss Day, that doesn't mean anything. This is the only thing that means anything. And so then, like, for example, if I go, I'm still on this first one, right? Like if I go to the physical evidence, this should never change value. So paper is different. So if you documented, I gave over this document with this many pages and identify it, then it doesn't matter. I don't think that they're asking for a same trial file, what they are asking for, and that what this court should ensure, because these cases must stand the test of time. It has to be able to be, and I will tell you, like, it is a concern. Like, the different platforms have to be consistent for now and future review. Okay, so this is kind of where I'm at. I don't necessarily think, from what I'm hearing from both sides, that you have to start totally from scratch, from either side. What I think needs to happen, and where the state because we're too far in, right? I think what needs to happen is the defense needs to identify the problematic electronic evidence, and that's where I see the majority of the problems coming. The electronic evidence of the multiple versions, okay? And I don't know, the hard drives that you all have gotten where you have the problematic electronic evidence, where it's the multiple downloads. What I would ask is that the defense identify those problem downloads, okay? The problem electronic evidence. That is where we're going to focus, okay, in indexing, okay? We're not starting from scratch because we're too far along. Then when you all see the problems, and maybe, does it have any potential of having like attorney-client privilege, or are you just giving back what they've given you? Or is there a way for you to duplicate how you are seeing it? Do you understand what I'm saying or asking? Okay, so let's say, I don't know what this is because it's just a bunch of numbers. It's, Defense Exhibit C, whatever this is, okay? Could the defense somehow duplicate that for the state, give it back? Does that make sense? Like, so y'all have identified, I don't know what this is, these files, okay? Duplicate it. Say, this is what we want indexed. Is this, what is that? Who is that? This is what we want indexed, okay? And then the state, you go through and index that and give them back what you are going to use in an index form, what you all are proposing. Does that make sense?
It does, Your Honor.
So y'all are not just going through and saying, we're going to redo everything. It is what they are having problems with. So if they have basically, and if y'all have different values of electronic evidence that you all, maybe it's not on this evidence.com, but you all give them back a hard drive with whatever this is. If y'all have to buy 900 hard drives for each individual thing with an index on it that everyone is working off of, and this is what you're going to use, then minus whatever evidentiary redactions may be needed in the future, but you're giving them exactly what you're going to use, not a download, not a user error, but something that they can plug into a computer and say, this, we can count on that as being what the state is intending to use.
Yes, ma'am. That was the thought process behind this. I told them whatever we indexed or tagged, that would remain the identification number for our exhibit list. That would be what we're using at trial. We're not going to use a different version. That process has begun.
Do you know what their problems are?
Somewhat. I think I have Detective Padilla, who is cross-sworn with Jacksonville Sheriff's Office and the Secret Service. I've given him a chart where I have put in one chart all of the devices where the extractions are housed. He's going to the original data. He's going to pull an original copy of raw data and UFDR for all the devices minus their clients. He's going to make a chart with the hash value, file size, and confirm the data is complete and perfected, and provide that list to me and to defense. I will
No.
to defense.
No. They need to identify. You can do that on your own, but like they need to identify where their problems are. And so instead of you doing all of that, you wait for them to say, these are what we have been working on / concerned about, and then you all give back exactly what you're going to use related to those particular devices.
Yes, ma'am. And Ms. Day's provided me a list. I'm working on that. But I only say that for the court to understand that Detective Padilla will be able to give us the confirmed hash value of all these devices, so they can let me know what hash values they have. They can tell me they're missing a download, but if I have to compare it to this list to see if there actually is a problem or if that's the actual file size. That's in process on the state side. Whatever they give me, I'm happy to cross-reference and re-provide. Ms. Day has already given me a list that we've been working on. I did a partial response on state's supplemental discovery 1 to one of her lists, and I told her to, if she numerically listed it, that I would respond numerically as well, and we can file those with the court as a request for discovery and discovery response.
Okay, so that I am, because I mean, I'm not privy, nor do I want to be privy to any of y'all's emails. If the defense would identify through either motion to compel or motion, some type of discovery motion, what you are duplicating / giving to the state as far as problematic. And when I say identify, I mean, let's say, I'm just going to hypothetically, it is, I don't know, Henry Tennant's cell phone, like you said earlier. Henry Tennant's cell phone, version 1, 2, 3, however many you've gotten, right? And then you say motion, and then date tendered, then motion to compel Henry Tennant's actual download for what you, that is state, what you intend to use. It sounds to me that this evidence.com is not a usable / workable format, so I'm not sure. I understand it might be their operating system for like a law enforcement aspect, but for court purposes, it is creating too many problems.
And the benefit to it, Your Honor, just so you understand why we did it, is for the very reason that rather than me plugging their hard drive or flash drive into my computer and transferring something and giving it to them, because I am operating off of, that's the evidence that Jacksonville Beach Police has in their possession, that I have in my possession, they have access to download it, we ensure that we all are looking at the same evidence.
But you're not. You're not. And that's what's creating the problem. And it might be usable for you and law enforcement. It is not usable for the defense. They have been saying now, I think for about 13 months, that they are getting this, and that is not usable. And also for court purposes, for record purposes, it is not corresponding to what I couldn't make heads or tails of this, to be honest with you. Like, this list is wonderful that is on the back of this exhibit listing all the evidence, right? But it doesn't correspond to anything. So, and I understand that you all want to index, which I think is great, okay, if you all were working along the same lines and you could say on state's exhibit, whatever, this and this, but they are looking at numbers. And unless you know what numbers they have, there is no way for you to properly index it for review where everyone is working off of the same thing. That is what I'm trying to explain. So what I want, and by the next court date, I want the defense to identify the problematic, okay, electronic files. And how many versions you all have. To the extent, and you let me know if this is a problem, but, you know, because I'm working in an unfamiliar area, right? So if there is a problem with you all duplicating what they gave you, not anything that y'all, like your work product, right? But what they gave you, if you could duplicate it back to them. And then once the state has the problematic evidence, okay, then I'm going to meet with you all, and you can give it to, I'll give you some time, you give it to the expert, okay? And I need to know from whatever law enforcement or whoever, whatever, is able to review it. And I want to know how it is going to be communicated back to them. The way that it is communicated back to them, that is disclosed back to them with on black and white paper, okay, will be what it is going to be, okay? So that would ensure, hopefully, that what the state is saying is going to be what will be in this case, period, end of story. Not some cloud manipulated user error download. And I want to know like how big it is or whatever, and if you need to bring these people in, explain to me how it can be disclosed to them in a way that we can all be confident from this day to the last day that it will remain the same. That's what we're going to do, okay?
I understand, Your Honor. And looking at this is the first time Exhibit C, I'm seeing what they're seeing, so.
I know, but they have been saying the same thing.
Well, and Judge, I think one way we can do this, and we'll work towards this effort once we receive the problematic list, that's adding another column to our spreadsheet of our index. So we're going to have all that, and then we're going to have their identifying factor corresponding with what our corresponding factor is.
Okay.
That's
So,
really.
I mean, when y'all are looking at these numbers, do y'all have it cross-referenced, or are you just doing what Mr. Carodi said and just changing it to whatever y'all remember it to be?
Change it, but also, as we said many times this morning, because
I can't hear you, Miss Day.
because we have received so many duplicates, and not just true duplicates, but partial and reorganized and relabeled. It's not just necessarily, we download this from evidence.com, I identify this as report supplement 152 and label it as such. I then have to go back through what we have already saved, download, and reorganized to see if it's something that I already received.
Let me ask this, okay, for the defense. Let's say y'all identify the problematic electronic files, okay? And then I would, when I say duplicate, meaning that y'all duplicate it for the state, y'all have already gone through these things, correct? Okay.
Well, not that, we've gone through in the sense that we have downloaded and logged that we received it, and potentially whether or not there was an issue in opening it. By no means is the defense saying that we've fully reviewed every Google return or cell phone download. That is certainly not true.
Okay, I'm asking, okay, for record purposes. So if you all you all duplicate the problematic electronic evidence, right? Then you send it to the state. You file with the court under seal, okay, for later review if needed, okay? And that seal will mean that those versions, 1, 2, 3, 4, 5, however many they are, I would enter an order excluding them. Excluded. So then with the state, you all have the problematic files. You simplify it into the file that will be used, okay? So whatever gets communicated back, they can count on that is what you are going to use, okay? Not version 1, 2, 3, 4, 5, but this version that you will amend your disclosure back to them, okay? That will be what it will be, okay? Forevermore. The ones that you all duplicate and file with the court under seal will be excluded from evidence, so that everyone will be working off just whatever you provide this final time. Does that make sense? So then it's not any cross-reference. What my thought process is, okay, is if they give you back what you gave them in these number forms, you can give it to whoever is reviewing this, and he can confirm, maybe it is user error, maybe it is some type of interruption, but he can say that, okay, I'm compared these, not them, not their time/expense, your expert, he compares all this, and he says, this is the actual version, and give it back to them. Does that make sense?
It does, Your Honor. And
Okay, so-
we're sort of undertaking that already.
You're not, I know, but like y'all have been telling me this month after month, day after day, and what is occurring is the state is doing this, but it's not being communicated in a way that anyone can be confident that it is the evidence that will be potentially presented. So for their investigative purposes. So from that sense, the problematic electronic evidence will be excluded. Whatever y'all identify, it will be communicated back to the state of Florida, okay? And then what you amend / disclose to them at this point in time is it, okay? That's it. And then so like I said earlier with that next point, evidence.com is not workable, okay? So you all have to find some way. Evidence should not be able to be manipulated. It should not be able to be like you see one thing, they see another. Evidence has to be reliable from all standpoints. And so you can say user error all you want, but we need to get a way that there is no user error. Okay? So by the next court date, it's just going to be, as Mr. Khalil put it, dinosaur. It is what it is, okay? It's a bone buried in the desert, okay? It is what it is from this point to the last point. And so evidence.com is not workable, okay? Unless you can somehow bring someone in here that is going to tell me that they would be able to download whatever without any user error, okay? So otherwise, if someone is going to tell you that there could be user error, then you need to find another format, either 100 computers or whatever you got going on, okay? So, anything else about this electronic evidence? So you all are going to identify, that's y'all's to-do list.
Judge, I think that was the purpose of our expert coming down and looking at, I mean, we think it's all problematic. And that's why we had wanted our expert to come down, look at the original raw data on the police officers' drives, look at the original devices, and say, this is a good copy. And so that was the impetus behind our expert coming down.
Mr. Crody, you're backpedaling. So let's just put all that in the rearview mirror, okay? Y'all are going to say that this version, that version, this version, you're going to say, we have looked at this, it's problematic, it's got, this megabyte, this terabyte, this, and just dump it, okay? Then you're going to file it. Okay, so that if needed, y'all will have it. It will be a copy back to the state. It will be a copy to the court, kept under seal, okay? Your expert will have it, okay? That will be excluded. You understand? It will not be evidence, period. You're gonna communicate back. They are gonna then give you what their final version is, and something that if it's 5 terabytes over here, it will be 5 terabytes over there. So you don't have to worry about it, but you'll have those other copies. So if it becomes necessary, y'all can compare it. You can raise issues. You see what I'm saying?
And their expert, yes, when we complete this, I've already reached out to the council for future dates. We are happy to do an evidence view with their expert once we get this filed and tell them what size the files are. They can examine the original data.
Okay. Do you see what I'm saying?
Yes, sir.
So let's put that in the rearview mirror. And I'll address that if you want to bring it to my attention about this canceling or whatever. But let's just I'm not having any sanctions motion. I'm trying to get to a point where we can move forward, all right? Are you with me or no?
I'm with you, Judge. I don't think you understand the Herculean task that we have been faced with in this case.
I'm trying to.
Discovery.
I agree.
And now, as I think about this, I understand what the court's trying to do, and I think that if we're just focusing on the devices, there aren't that many devices
I'm not focusing on devices. I'm focusing on what you all consider problems. Y'all have been telling me that y'all have been wasting time downloading this, downloading that, takes too long, whatever. Y'all tell me what your problems are. And that's why I cut Mr. Khalil off, because I don't want y'all starting from scratch. We're too far in. What I do want to do is address the problems. If you have multiple versions, they won't be allowed into evidence, but you'll have them. So if y'all want to investigate to see if this final version, that what they are going to be able to potentially use, you'll have it, but it will be for exclusion purposes, a part of the record, okay? There are 9 versions of Henry Tennant's phone will be filed with this court, will be communicated back to them and say, because they are not seeing what you're seeing, okay? And y'all are seeing 2 different things. They think they're solving a problem, but they're creating more problems for you. That is why we have gotten ourselves in this little pickle, okay? Because they keep saying, we're gonna do it. And y'all keep saying, when they do it, it's a problem. And it's a big problem because it's a lot of information, a lot of evidence. And so we're scratching all of that. Y'all will still have it. Your expert will still have it. Whatever they give back, that is what your expert needs to look at. Because all of that other stuff that y'all have been doing is excluded. The only purpose in it is that when they give you whatever this final version is, y'all have the time, if you want to compare it, but it won't be admitted into evidence the way that it was. So y'all will have some confidence, hopefully, in what this electronic evidence truly is. And I'm not gonna let these problems like sit around and fester, okay? If I need to talk to whoever, this evidence.com, this next point, whatever, is a problem. It has been a problem from the outset of this case. And so we need to get into a form where it is rock solid that y'all have confidence that whatever is being communicated is what y'all need to investigate and spend your time on, is where I'm at. Mr. Crody.
Judge, I understand your effort, and we'll comply.
What is the problem with that? Well, you're saying it's a Herculean task, and y'all have already downloaded whatever. I understand all of that. But, I mean, otherwise, just sitting around saying it's a problem, what would you suggest?
I have been concerned, and I remain concerned, and I do think that an index would be helpful, okay? I think but if they can compare it to what we've already have, that would be very helpful, because I think while there are problems with the devices, our solution that we had was to send our expert in to get the original data. Like, that was our solution, to make sure that we, on behalf of Ms. Gardner, were not missing anything. Okay, that was our solution. We have not been able to, we know we spoke to the court about that was our plan. We have not been able to accomplish that with regard to the devices.
Okay, well, let me ask you this, okay? If you don't want to do what I am suggesting, and you want the expert just to come in and look at what they have, and you, Ms. Gardner, leave it the way it is, Ms. Gardner's issues, I thought y'all had common issues, that is, common multiple versions of everything. If you want your expert to go through all the versions that you have gotten and then go through potentially a final version, I'll leave that the way it is. What I'm seeing from Ms. Day is that you like the solution that I've given, which is I will suppress/exclude the multiple versions. You get one version back from the state, and that is what is going forward with Mr. Fernandez. Mr. Crody does not. Y'all don't have to be on the same page. It doesn't.
And I'm not prepared to tell the court right now which way we want to proceed. I don't have the knowledge of what exactly we're dealing with to tell the court which way I want to proceed.
Who's doing the discovery for Ms. Gardner?
There are several people doing the discovery because it's so voluminous, but I think we need to.
Who's the lead on it?
Probably
Ms. Medina
and Ms. Rapetti, but I need to we need to talk to our expert and ask him, I'm just not prepared to tell the court today that's an acceptable solution. I'm just not in a position.
How long is it going to take for you to talk to him?
Probably a few days.
My detective spoke with their expert. He did reach out to him when we got his email before he canceled his trip and asked him what format he wanted everything to be sure. My detective has conveyed that information to me. I've conveyed it to our expert, and we are prepared to gather it in the format he wants and have an evidence view end of April, early May.
In what format?
He wants to look at the data he wants to look at the original extractions on their computer, and he wants a first copy of the original extraction, which we're providing to him. Both the raw data and the parsed data.
Okay. When?
I sent an email to defense counsel. Their expert said he would send us a hard drive because he wanted to look at some things before he made the trip down. And I said I sent an email end of April, but I think probably, to be realistic, sometime in May would be best.
No.
Hi, Judge.
Hello.
This is Michelle Medina on behalf of Ms. Gardner, and I'm sorry for the noise on my way to court. But I've been listening. I've been dealing specifically with the digital evidence.
Great.
And the issues that we're having, Judge, we've provided the state with a list of all of the digital forensic evidence that they claim to have in their possession. And I've specified on that list what we just do not have. So it's not an issue of we received one version and we want another, is we do not have it, period. And so the goal was for our expert to just go and just retrieve everything they say they have and just get it directly, instead of having to wait to get a copy, see if it's a readable version, and then relay it back to them. So I think the best way, just for sake of time, is just to have our expert meet with their expert and retrieve the evidence directly. And that.
Ms. Medina, you said that how did you give them that list?
In Word format. I actually have that list, and I can provide the court with
Why don't you do it in order to compel? So Ms. Gardner's issue is not multiple versions.
Well, we have multiple versions as well. This is just, it's a side issue of there's evidence that we just do not have that's digital. So it's two.
And it's also, is it the ones that you don't have, meaning that they need a taint review?
No, it's not taint related.
Okay. Well, all right.
That's why I
Do you
think
wanna,
because we're lawyers, and I agree with Ms. Stifler, sometimes it can get lost in translation with the technical terms. That's why even my expert had said, let me just deal directly with your expert, because they understand each other, and just schedule a time and get it directly,
Okay, I'm fine with that, okay?
Okay.
But I do want it documented some way.
100%. Yes.
Like, I want it documented whatever you're missing, okay? So if you'll do that,
Yes, Your Honor.
maybe as a motion to compel. All right. Mr. Carodi is the naysayer in the room about my solution. What do you think? About the multiple versions is what I'm working on.
Yeah, no, I think that's a good solution with the multiple versions. My concern was more of what we don't have and delaying that process.
No, I'm not. Okay, we're thinking about different problems. Okay, so I'm on multiple version solution, okay? Multiple version solution, which Ms. Day seems to be signing on to, and Ms. Medina, since you are in charge of it, okay, which is that whatever multiple versions you have of whatever evidence that you then, do you have an issue with the copy being filed with the court under seal? So, but y'all will still have all these versions, so whatever the final version is, you can compare if you want, but you know that those versions would not be admissible. Does that make sense?
Okay.
Are you with me or no?
So you're saying that you would receive a copy of our copy?
No. Y'all would make a copy of what you consider to be problematic. So have you seen the filing by Mr. Tassoni?
Yes. Yes, I
Okay.
have.
So what I am gathering from my questioning is that, so Defense Exhibit C on Mr. Tassoni's filing, okay, has, I think, hopefully, enlightened the state as to what you all are dealing with,
Yes.
okay? Because whatever they are looking at is not what you are looking at, and then that is what part of the problem is, and they keep trying to solve issues based on what they are looking at, but you are looking at something different. So my thought was, you all make a copy of whatever you all believe to be problematic. And when I'm saying problematic, I'm not saying things that you have not gotten. I'm saying what you have already gotten. Let's say you've got multiple versions. Ms. Day has communicated what one of Mr. Fernandez's issues is that, let's say, and I've been using this as an example, I don't know this to be the case, but Henry Tennant's phone is a 5 terabyte on one version. It's a 3 megabyte
Yes, that is
on...
correct.
I'm
Yes.
sorry?
Yeah, that is true.
Okay, so that's where I'm at, okay? Are you with me?
Yes.
So that is what you would make, whatever copies you all have received, okay, you would make the copy of what you all have seen, meaning the numbers / files that has been filed with this court now that make no sense, okay? That is not what the state sees when they are, I guess, providing it to you, is what I'm gathering. So you all give it back to them, you file it with the court, what you have given to the state saying these are problems, I would exclude it.
Okay.
Okay? So we know that, let's say version 1, 2, 3, 5 terabyte, 3 megabyte, 4 whatever byte, okay, is excluded. Y'all would still have it, but the state then amends and would be able to provide you with one version, okay, that would be indexed, whatever, that is what they're saying in a trial, that this is what it is the day that they provide it to you to the end of days, okay? That's what my proposal is.
No, I think, I guess my only concern is really the logistics of the copies because they're huge files.
I mean, why can't, instead of trying to, like, what I'm saying, we break these things down into whatever they may be. For example, like, if it's one device, you get one hard drive, not some huge cloud, whatever.
Oh boy. Okay. That's just I would want to have that conversation with Shannon. Because I think in this format, it can be done with specificity.
Right.
And there's already documents of that specifying, we received this on this date. This was the file name. This is what it shows. I mean, we have that written out. My concern is just providing chunks of the electronic format, just because just downloading it takes hours, sometimes days. So my concern is just now copying it. Could it take just as long? I don't know, Yeah. Is my concern.
I don't understand.
It's like just the digital part, the digital copy.
The reason we did cloud-based nextpointevans.com is because it is a quicker, more likely to download properly and completely than hard drive to hard drive.
All right, this is a capital case, all right?
I understand, Judge.
This is a capital case. This cannot exist in some cloud somewhere. It has to exist of record. These clouds don't exist.
It's just a conduit to deliver the discovery to them, the same way the portal delivers discovery from our office to the
Understood.
office.
Understood. Okay, so let's say down the line, this is a capital case. It has to be filed in a capital way. And so if it's never anything and it's up in some cloud somewhere, that doesn't make any sense to me, okay?
Which is the reasoning behind the state putting all this on a hard drive index and filing it with the court and then providing copies of that court exhibit to both defense teams, so that at least it's of record. The hard drive that we create and index will be filed as a court exhibit for appellate purposes.
Okay, so if there is ever a question about what they got as a defense team, how do we resolve that issue?
We can take, Your Honor, there's a way to take a screenshot of the, like when you open a hard drive, you'll see all the folders of how we received it from the state. And we could take a screenshot of that folder. It shows, you know, the size of the file. And then we can take a screenshot of that same, let's say, file showing a different size. And that way it's all documented. It's visual. It could be in a list format.
Okay, that's fine, but Ms. Medina, that's not how it looks to them.
Right, but they can see how it looks to us.
Right, but they don't know what to replace it with.
I mean, I would assume that they have what they gave us.
They don't.
You know?
They don't. That is what the problem is. When they look at it, whatever. So we're still operating on Mr. Tassoni's Exhibit C. 20, 24, all these numbers is in a file folder. Okay. When they look at their file folder, it says subpoenas. For you, it says 2024 1, 2, 3, 4, 5, 6, 7, 8.
Right, but they should know that they gave it to us on this date. Like they should have. I mean, I am assuming that the state would have documentation that on this day we gave the government, and they see what they provided to us, and then we can show what we actually received through screenshots. I mean, that's just my initial thought process. But like I said, I really have to talk to Ms. Day.
Have y'all sat down and said, I click on this, it's this, with the state?
Your Honor, that quite frankly was our plan for the deposition with Mr. John.
Yes, correct.
We had lots of questions on just how to open files, trying to figure out if they were complete or not. I'm totally understand some of this may be user error and not download error, but I have no way of knowing that without comparing it to a correct and accurate file.
Okay. But what I'm hearing from the defense is you don't want to start over. The state wants to start over.
But I mean, quite frankly,
I think what we're
quite frankly, oh, sorry, Pat. Go ahead.
I think what we're saying, Judge, is going back through the state's discovery exhibits, they have been woefully vague. And I think it would be helpful for everyone if we had a complete index of what the state believes that they have turned over to us. That, for example, going to the paper example, we have files that say Henry Tennant's jail calls. Okay, that's how they disclose them. We get them, and they look like a ton of numbers. Now, I know how many files are there, but if they're saying that they disclosed 27 of them, I would like an index that says they've disclosed 27 of them. And so I can go back through, or even more detail, if they're willing to give us more detail. So I can go back through the files that I've received and say, okay, I have 27 calls. What I don't want is for them to give me a new folder that says Henry Tennant's jail calls that I have to click on and say, okay, there are 27 there, And now I have to open my file and say, okay, there are 27 there, are they the same? That would be, but I do think there is value in an index, and especially if they can relate it back to when they turned it over to us, and then we have all the evidence.coms downloaded by date.
When you downloaded them?
We have them downloaded by date, so if they.
And so if this trail that Ms. Stifler is talking about, if she can compare it to the trail that they have?
And provide us an index, and this is probably separate and distinct to the multiple version issue.
Well, we have not even finished that problem, Mr. Crody.
I know, but I do think there is value in that. Our concern, and I think I speak for Ms. Day also, is you're going to give us a new hard drive, and then you're going to say, well, you guys are bound for that at trial. And if the state uses something on that hard drive at trial, and we're like, oh my God, we never saw that, they can say, oh, we gave it to you in the hard drive. It's on the hard drive. Well, that makes it that we have to start anew, and that's our objection. What we would prefer the state.
No, that is not what I'm saying.
No, I understand that, but what I think we prefer is that the state does give us a detailed index, and it includes when they turned it over, so that we know when we got it, and we can go back and cross-reference that, as opposed to doing a new hard drive. With regard to the digital part of it, I understand the court's concern. I do think there is value in what Ms. Medina was saying, in that if we can determine how large the files are and what we believe they reference, I think that would be, that would, and then I think what happens is the state turns over a new copy of it, for example, Ms. Jensen's cell phone, and gives a copy to the court, and that becomes the copy that they will work off of trial.
This court does not need copies of the discovery. What I was proposing is that I keep copies of things that are excluded, so that y'all would get it back, and you would know that these multiple versions, I don't care if it's a copy, I don't care if it's a screenshot, that there is some reference in this court of what is excluded and what will be worked on. That is my thought.
Judge, I think the inverse is true, because if there was a disputed trial versus what was excluded and what was not, you would be able to figure it out you would inevitably have to go to the copy that they turned over. You wouldn't go to the copy that was excluded, you would go to the copy that was turned over to determine if the information was in fact turned over. And that's why I'm proposing that essentially there be a copy deposited with the court as to what they are going to, with regard to the devices in dispute, as to what that they would use. I don't know that providing the court copies of what the court is excluding.
Well, it has to be of record what you are turning over to the state, and then and I would say that is not admissible, then they turn back over what is admissible. So we are not working off of multiple versions, that y'all would not be referencing some old, I don't care if it's an actual copy or whatever, y'all make a copy or reference somehow, like if it's too arduous to duplicate it electronically for the state. My thought was that if you did at least identify in some way that their expert could verify, and then we say that is not going to be the evidence in the case. Instead, the amended whatever index that y'all come up with will be the evidence. So we can just kind of cut all this off. That I'm trying to get to one version of whatever y'all are concerned about. That's what I'm trying to get to. Whatever I am operating, a little bit in the dark, that I don't know what these things are or how it's best accomplished, but what the problem is that what I'm seeing on the filings is that what y'all are seeing and what they are seeing are two different things. And so if I don't speak, French, you saying something to me means nothing, okay? And that is what has been going on. And so I'm fine. I'm not gonna, I'll wait. okay? I'll let y'all have the conversation. I'm not gonna wait y'all are not gonna get all these long past dates anymore, okay? Because it's too problematic. If I want answers, it's gonna happen quickly because, we are too far in. So that is what I'm thinking. So on y'all's notes, let's start from the top, okay? Problematic, multiple versions of electronic evidence. All right? From what I have heard during the course of this case management hearing is that we need to get to one version. I will let y'all talk offline about it. I've given you my potential solution or thoughts about it. You all have the majority of the working knowledge, okay, to get us, which is any goal in any criminal case, to one thing, whatever that thing may be, one. And so I want you all to share however you believe to be appropriate and accurate so that you all can get on the same page of what is the problem and then a potential solution. My solution is that we scratch just the problems and I don't want to work. What has happened in this case is there's so much and then y'all are dealing with so many problems. To me, it's step by step, one by one. So we are going to first deal with the multiple version electronic evidence problem. I think it is a great idea for the state to index everything. Wonderful. But what I'm only suggesting a solution to at this point in time, whatever y'all want to communicate as far as like trial exhibits or indexing, do it. Okay, do it. However, what I'm going to manage at this point in time are problems. Are we with each other? So you talking about indexing, great. You talking about organization, great. I'm not worried about that. Y'all are professionals, you can handle that. I'm going to deal with evidence problems, okay? So number one, we'll all write the same list. Evidence, electronic evidence, multiple versions. However y'all see it to be appropriate, the defense needs to communicate the problem electronic evidence to the state of Florida in the form that the defense has, okay? Whatever that may be, like how they gave it to you and how it is problematic. You understand? Like I'm looking at C. We'll use Exhibit C as an example. If the state looked at Exhibit C, okay, are you able to tell what that is in your file?
I should be able to search it by the file name within evidence.com.
Okay, great. So if that is, so let's work, I don't know what this stuff looks like, so I'm just using Exhibit C. So if you all are able to cross-reference Exhibit C with whatever is in your file and you are able to index it some way, make it make sense along the disclosures that have already taken place, great, that will be the solution. If it is not, then we need to scratch the way it has been provided and then provide the final copy. And then it is what it is. And so I will let y'all offline talk about that, okay? So that is going to be to do number one, okay? Then number two will be you all, Ms. Medina, on the missing electronic evidence. Is that the same for Mr. Fernandez or no?
It's been a while since me and Michelle have compared notes on what...
Okay, well, y'all can let me know. So let's, number two on the to-do. Missing electronic evidence. You all identify it, and it needs to be of record. So y'all's emails back and forth mean nothing to me, okay? Motion to compel, that will put the state on notice that you all are missing these things. To the extent that it has been referenced in some former state disclosure and y'all have looked at it and you cannot find it, show them where they have disclosed it, and then I will handle that at the next court date. So file that, okay?
Will do, Your Honor. Thank you.
All right, now, to me, problem number 3, I think, I can't remember the date. I believe it was back in 2024 where I want to know, so this electronic evidence has, to me, almost like overtaken everything else that y'all have been doing. Y'all have been working, right? And you've been deposing witnesses and all of those things. So at the next case management hearing, okay, what I did my best to count, cross-reference witnesses and physical evidence and things of that nature that have been done and need to be accomplished. Okay, so I want just a nuts and bolts analysis from both the state and the defense, what is left to be done as far as like physical evidence. And when I'm saying physical evidence, I'm saying like, is there any, I think I've asked this question before, there's nothing forensically that's outstanding in this case, correct?
There were some forensic testing requested by Dreiser Hill firm. I spoke with the ATF agent yesterday. They had anticipated completing that I gave them a deadline of March. So they know it should be completed shortly. So that's it, though.
How was that requested?
I requested they complete the forensic testing by March because...
No. So the defense asked that...
There was a particular swab that they wanted DNA testing completed on.
But you didn't file a motion?
I just agreed to it.
Okay.
They can file a motion and you can, for record purposes.
No, I mean, okay.
I'm happy to file, but the state did agree, so.
And we had some other swabs submitted.
save you one.
They had asked for all forensic testing when we had the October trial date be completed
Okay.
6 months ahead, so.
No motion needed, okay? However, what I would like is some documentation, because this is the first I'm hearing of any of that, okay? There needs to be some type of documentation, either a consent order of
Understood.
what you all, what was requested and what was, or some type of, there needs to be some type of documentation of the request and then the agreement of the evidence that was tested.
I did list the swabs on a supplemental. I can't remember if I parenthesized it requested by defense or not, but I can file something reflecting that. When I receive the testing and disclose it, I can put that in the supplemental.
Okay, that's fine. So whatever evidence was requested by the defense that was tested by agreement by the state, when you get whatever results, that needs to be documented in some way.
Yes, Your Honor. That should be shortly forthcoming. ATF, I requested it be completed by March, and I followed up yesterday.
Okay. Now,
And
the witnesses.
yes, for Your Honor's information, I'm looking at Ms. Gardner's case, docket line 318. In December, I had filed a state's exhibit regarding depositions. And
Right, I tried to go through that.
I listed all the depositions we completed in 2024.
Right, and then I did look at that, and then also with some of them were completed later, and then there have been depositions since that time
Yes, Your Honor.
that have not been documented about who was completed. What I'm really asking is what work is left to be done witness-wise, okay, next court date.
Yes, Your Honor.
I need an outlook for that. But it looks like, I mean, y'all have been working diligently through the witnesses. And the other problem that I wanted to, I'm going to put it out there, I want an answer. The defense has filed requests for specific discovery that is longstanding in this case, and the state needs to respond by the next court date. Do you know what I'm talking about?
I think there was a request for, we had done one filing. I will go back and make sure we respond to all outstanding requests for specific discovery. I think there was a request for some body camera footage in regards to Henry Tennant's arrest on unrelated charges, which I'm happy to provide, and we'll file a response.
I think it's in Mr. Fernandez's case.
All right, then the one I'm referencing is one in Ms. Gardner's case. I'll respond to whatever's outstanding.
It was what I brought up earlier about jail calls that exist. And they also wrote in Mr. Tassoni's filing that they have done a public records request, but to the extent that the state has memorialized those.
Yes, ma'am, and we just have not had an opportunity to respond to Mr. Tassoni's latest filing, and we plan to do so in writing.
But it was referencing what was filed
Yes, ma'am.
way back. So once you all get together, you meet about whatever the multiple evidence, the missing evidence, the consent apparently is not an issue. If the physical evidence has essentially been examined or whatever, I did see that, I guess, some of these experts and things like that have not been scheduled for any deposition yet.
We have not scheduled what I would say would be, the law enforcement that played an integral role in investigating the case.
All right.
That's really who's outstanding.
Okay. And then, but also these forensic experts, both computer.
Correct, because we haven't, we.
Right. Well, I mean, that makes sense.
Yeah, we've been, and the DNA testing's still ongoing.
There are some,
Is there?
yes, I'm still.
Oh, the ones that were requested.
Yes.
Okay.
It's the same analyst, and there are some experts in regards to cellular site data and location data, FBI and ATF.
Is there any issue with wires?
As far as,
We've been spending, like,
I mean,
with the
we're gonna
devices.
We're going to file a motion to suppress the wires because we think it was a bad wire, if that's what the court means.
Okay. Let me I'm not asking, that should have been a better question. What I'm asking is there any issue with disclosure of wires that you all are able to, I'm on discovery, not motion, so is there?
To our knowledge, what I can tell the court is we have received many recorded wire intercepts that.
I saw on one, it's 230.
Yes, Your Honor, and I also provided, they're transcribed, I provided transcripts to defense counsel as well.
Is that disclosed?
No, I didn't specifically list transcripts.
All right.
I can do that.
Look, whatever you are giving over needs to be of record. And so if this is in this master index, that would be great.
That's
Okay?
fine. I'll let the court and defense counsel know. I am organizing and planning to file a chart with specific statements of both defendants I plan to introduce at trial. I've been trying to be specific in their statements and my disclosures, but there will be a master list with a motion for pretrial ruling on admissibility for some of the statements in regards to their cases. So they'll have, prior to trial, an outline, all the statements of co-conspirators, all the statements of co-defendants, all the statements of specific statements of defendants I intend to try to introduce at trial.
All right.
And that would include the wires, any digital evidence, reports, interviews, that sort of thing.
So this, I'm not I do think the index would be very helpful for everyone. But what I'm trying to do is, like, on the back end of whatever index that you all, before you start creating something new, that you know where the problems lie, so that the index that you all create for whatever reason is addressing their problems. And I know that you all have been trying to address problems, but the problem is that y'all are not on the same page as about what is going on. And so when you get the list of problems that the index, it'll be great. You can say that issue is addressed on index line 1012, okay? But what I really want to do is address the problems. And so if y'all want to have some master index, great, okay? But what is at the forefront are these problems, these problematic things. The majority of it is in electronic information.
I understand, Your Honor. I agree. I think it's prudent that we put it in writing in the record instead of just doing emails. And I will say, I want the court to understand, Ms. Day and Ms. Medina have been working very hard and collaboratively with the state. It may not seem that way from this hearing, but I do think that all three of us have been really trying to solve these problems.
I don't take that at all. I think what I do believe is that y'all are somewhat on the same page, but not totally on the same page. And that is, in this court's perspective, very bad, okay? Very bad, because evidence has to be what it is. And so, like, if people have multiple versions of something, there is no reliability in what is being put forward. There is no reliability in what they are spending their time on. And so what my thought is, and what is so important, especially in a capital case, that it is what it is. And so, like, that's where we've got to get. We are not there yet. I don't think we're necessarily far off, and that's why I want the defense to put not in, but like orders to compel, like, so that it is specifically identified what these problems are. And then I'll get to whatever else y'all want to litigate, but like, so that I have like kind of a clear understanding, honed down into what actual electronic files / electronic evidence is, where are the multiple versions, what, that listing, so that I can order responses to it in a timely fashion that does not frustrate the path of this case. So that's why, like, starting all over, I don't necessarily, some of this you are going to have to. But hopefully it will be just on a few things, maybe, not totally. Okay? All right, so how long is it going to take for y'all to do that? And then I want whatever, so that I want the state to confirm that it is 230, that's what I saw in the disclosure, is what it is, okay, with your index. If y'all don't believe that to be an issue, fine. So disclosure-wise. Then, the state has disclosed certain subpoenas. I'm assuming that this index would say, like, I know that you have written a supplement disclosure about subpoenas and response / evidence to it. This index will address those issues in a more succinct way.
Yes, Your Honor. And also, Ms. Day's numbered list, I can either incorporate that into an index, or if she's going to file that as a motion to compel, I'll respond specifically. There are times where we sent subpoenas and got no returns, and I tried to file it to reflect that. I know it's hard to disclose that.
Right.
In a way that makes sense.
Right. So I don't necessarily, if you have tried to do it, if it is in the index, that it needs to read almost like a sentence. For example, like I'm looking at, let's say, community first subpoena, date subpoena, whatever it is, no response. And then that should hopefully,
Yes, ma'am.
in a line of things, say that this was the date of issue, this is the return date, result on the subpoenas, because there's so many subpoenas. I counted, just on this first disclosure, I think I counted like 40,
Yes, ma'am.
44 subpoenas, okay? And so if the state could line those up in whatever index y'all create for this master, that would be, in my mind, helpful. So we'll just stop it there. So to me, I have two top priorities, which is what will be the focus of the next, which are these multiple versions, so that if you need court intervention about how we would deal with it, if you all show them how it is, like if it's screenshot, great. If it's, you have to actually give it to them, fine. But I'll look to you all to see how you all are able to potentially resolve this. If y'all are able to resolve it on your own, okay. If you need me to exclude/suppress the one and then y'all just start all over, that's what I need to know at the next court date, okay?
Your Honor, I do have one question. I understand the court's priority is the devices. That is a huge, substantial amount of the evidence. My notes do reflect there are about 198 subpoenas, and I do believe...
Well, I was only looking at that one exhibit, so.
I have them all listed. I do believe we are missing about half. So
Okay,
we see it as like an equal concern to the devices.
subpoenas.
Yes.
Okay, got it.
So I didn't know.
All right, so do that in a motion to compel. You list what, have you all referenced, like, let's say subpoena A has a result and you have that? So the devices or the subpoenas where you don't have corresponding response, list that in a motion to compel and put the state on notice.
Okay.
Okay?
Yes, Your
Not an email.
Yes, Your Honor.
Okay. So then everyone is operating on the same page and the state can go through whatever, and then we'll deal with how they have responded or how they intend to respond. If they have no response or what. How long do y'all need to do that? And don't say 30 days.
I know, I'm in a all-week trial next week.
Can someone else help?
Yes, we have a paralegal who's working on this with us.
As soon as we get the list of, Your Honor,
Right.
of what they believe.
Microphone. Microphone.
No, I apologize. As soon as we get the list of what they believe they need in the motion to compel, we will.
How long do you think? From the defense, how long will it take for you to compile it?
I guess.
And do it do one, okay? So from this hearing, this is what is missing, right? And do it just in sections, so then it can be communicated in the state and we can then deal with those.
Your Honor, my hope is that we have scheduled a discovery conference on April 17th amongst the parties. We hopefully will be able to have the answers by that time, if not sooner.
All right, you're just shy of 30 days then when I could probably do this again. All right, the other thing, so if you all are going to have those conversations, okay, if it becomes necessary from y'all's perspective to just have the experts talk to one another, or schedule on-site collection, or what, I don't know what y'all want to call that. I don't know. If you all will select a date and time, I'll put it in order, so then there's some teeth behind it, okay?
Yes, Your Honor.
Perfect, thank you, Your Honor.
I mean, I'm operating a little bit in the dark because I don't know what these things are. I don't know kind of what it takes, but if you all I appreciate y'all's patience with me, because I'm trying to understand it, but as to the extent that this court can help kind of unravel some of these issues, I'm happy to do that. And y'all, what I do intend to do from this hearing is designate this as a priority case. And as a priority case, it would take precedent over anything I have on my calendar. So if you all need me, I will make myself available at a drop of a dime, okay? So there it is, courts, actually the chief judge has made this a priority case. I will incorporate that / memorialize it in order, so that you all know that if you need me, I will be here. You will have the court time. I don't want these problems or miscommunication or whatever might be occurring to fester for days and days and days. If y'all get to a meeting and you can't get it resolved, you can have time with me the next day, okay? I do not want these things to kind of go like this. We need to, and to me, it takes maybe sitting down, hashing it out, and then I will intervene if I need to. I'm not going to intervene if I don't need to. So I will do that, so that you all know whenever you need this court, I will be here. Okay? All right. Thank you all for your time. Do you all have time? I have something, but I will reschedule it, as I've indicated, maybe April 25th, after y'all's meeting.
I'm out of the country that week, Your Honor.
Okay. The date and time, how written in stone is that April 17th date of a discovery meeting? I say I come before that. I can come in before that
Yes, ma'am.
to get answers. So I'm available next week. I'm available the week of April 7th, and y'all tell me a time. Isn't the bias firm unavailable?
Through April,
I believe it was April 1st, Judge. I know I'm unavailable the 9th, 10th, and 11th doing the death penalty CLE, so I need to get those hours for my certification.
All right.
Your Honor, I'm in an all-week trial next week, but maybe April 8th, that Tuesday.
Okay.
Sorry, the dates again were April 8th, 9th, and 11th?
Mr. Corody said he's unavailable the 9th, 10th, and 11th. He's in a death penalty CLE. So right now, y'all can have plenty of time with me next week.
I think Ms. Stifler said she was
Oh, she's in a trial.
I'm in a trial in front of Judge.
There's nobody else that could just get answers?
I can get answers and relay them to co-counsel. If that's when Your Honor wants to set it, somebody can be available.
The 8th is, I think the 8th would work.
If we do the 8th, I'd have to do early morning because I have 4 trials set. One is a speedy issue. So I could do special set at 8 a.m.
I can do that.
State's available.
Yes?
Yes, Your Honor.
All right, y'all got it. April 8th, 8 a.m., special set, case management hearing.
That's to see where we are in the devices.
Yes, and then from that point, once y'all hopefully have figured that out, if y'all want to proceed with the sanctions and things of that nature, I would schedule at that point. That will give the state time to review Mr. Tissoni's latest filing, and y'all can tell me. And like, if you want partial review, or you let me know at that point in time, and I'll schedule the hearing.
Yes.
Okay?
Yes, Your Honor.
And one last update, we did receive an email late yesterday from Mr. Gano. He was able to complete the filter procedure on Ms. Gardner's Apple iCloud, and he is prepared to send that to defense counsel for review.
I thought it was the phone.
When he says Apple phone, he means Apple iCloud, I believe.
Okay. I guess we'll see when we see it.
See, y'all are talking two different languages. All right. See you. All right. We'll see y'all next time. April 8th, 8 a.m.
All right. Well, that was an interesting. That was an interesting 2 hours of discussion. But check this out. I think this will be fun. We have a couple more hearings to listen to, but here, check this out. Because they were talking so much about evidence.com, I found this for us. I thought this was pretty cool. I know Florida PI
Every
Sam.
day, more and more
Florida PI Sam can talk a lot more about evidence.com than I can, for sure. But I did find this. I thought this would be fun to watch. Let's check this out.
Every day, more and more agencies are adopting body cameras. What does this development mean for prosecutors like you? Better video evidence than before, and more evidence to manage than ever. We think the evidence sharing process is broken when agencies have to burn evidence to disks and ship them off to you. Then you have to share the evidence within your office and prepare files for the defense, the public, and the press. This process could take a week or more. Well, what if we can make sharing files easier? Enter evidence.com, a secure digital data management system used by prosecutors and law enforcement agencies across the country. It's easy to use. Once an agency creates a new file and shares a case with you, you'll be immediately notified. With just a few clicks, you can accept a case and share it with others. Now, a week-long process can take you just a few hours, if that. Concerned about security? We are too. That's why we employ industry-leading security practices that have earned us the trust of thousands of agencies on our platform. All your actions are recorded in an audit log to ensure chain of custody and authenticity. And don't worry, your files are still admissible in court. Ready to live in a disk-free world? Evidence.com's free standard plan may just be the answer to your office's evidence sharing needs. Contact us to learn more.
And Axon is the body cam, right? So it's pretty, it's pretty legit. So I don't know what happened with the state was saying it's user error on the defense side, and the defense is saying, well, we're getting all this information, and it's just not, we don't understand their folder structure, and it's duplicate copies, and it's not, we're missing things. So, well, let's see if they sorted it out. Let's go to April 8th. Let's see if they sorted it out. That's the wonderful thing that we can zoom through all this stuff, and we see the issue, and now let's see if they have an answer, have a solution. Hello there, buddy. Nope, that's my water. That's not yours. Keep it moving. Keep it moving. Nothing to see here. All right.
All right, I want to apologize for the delay. So we are here. The defense has filed several motions. I have an order designating these cases as priority cases. I have copies for the attorneys. Can you staple these? I understand that the state was going to start an index.
Yes, Your Honor.
All right. Do you want to tell me what the status of that is?
Your Honor, I was in a week-long trial last week. I did meet with my paralegal yesterday. Our paralegal has been designated to work solely, not exclusively, but mainly on this case. He's begun indexing discovery. He's indexed about 4,500 pages of discovery thus far. He also has been working on the joint motion to compel discovery, which was filed by Defendant Fernandez and adopted by Defendant Gardner, and we are beginning a written response and provision of some of these things that are missing. Some of the items on this are not items that are missing, but questions the state can answer, and I'll do so in a written response. Detective Padilla with the Secret Service and Jacksonville Sheriff's Office Computer Forensic Investigations Unit has begun the process of, other than the defendant's devices, all other devices in the case, reviewing the original data to ensure the data is complete and hash valuing all of the devices so that we can provide a file size and hash value for each device to defense counsel to ensure that everybody has the same data that they're working from. So I believe Gardner's team filed a motion to compel electronic discovery, so that's underway with Detective Padilla.
Is there any objection to that?
Only to the time frame. They requested that we provide that within 30 days. I've spoken with Detective Padilla, just because it takes time to rerun the data. I don't know if that's realistic for us to complete it, so I would be requesting, I have no objection to it, but I'd be requesting a window of 60 days, and if we run into any issues, that we'd be allowed to come back before the court and request an extension on some of the devices.
All right. So, how is this index going to work with the request for the specific discovery? It's over 100.
So I've looked through this, and my paralegals looked through it, and I have notes on every single item here. Some things I need to follow up and request from Jacksonville Beach Police. There's some surveillance videos in the property room that were negative evidence that I don't have. I would just, probably what's most prudent is I just file a written response to this in addition to the index.
What about the items where it says that it doesn't work? Like whatever you all have provided doesn't open for them,
Right.
It's in the wrong file format.
So there were a couple that I had my paralegal check himself. We were able to open them. I think it's best if I file a written response specifically citing to that number, just outlining for defense counsel how to open the items.
I'll give you an example. Like I believe it's ATF PowerPoint, where it says that you all provided it in a PDF and there is no ability for the defense to open that. I'll give you that as an example. Like, how is a written response going to solve that?
All right, specifically item number 5, ATF cell data location. That's actually FBI cell data location. There's a PDF of the PowerPoint. I will provide them a color copy of the PowerPoint. My response would be, there's no animation. I don't know what they're speaking about. So my written response would be, I will re-provide the PowerPoint in a color copy. I can do it instead of scanning a PDF to them, actually provide it to them, but when I email them the slides, I email them the slides as I receive them. The animation doesn't animate. There's color coding on the map that a color copy might assist them better.
All right, what's the defense position? Have you all met since this time?
As far
You can remain seated.
as far as myself and Ms. Day and Mr. Dreiser, or you?
Right. I thought also, Mr. Cleel, you might have said that you all were going to talk to the defense about the index. Am I not remembering that correctly?
Your Honor, where we were left was we're waiting for the defense to file a motion to compel. We have a discovery conference scheduled next Thursday, where hopefully a lot of this will be outlined as to what they're going through. I think the intent was to do what was requested of the defense, which is to indicate in this index where the files or the information was previously tendered and in what format, so that they can easily cross-reference from the original responses.
All right. You all said that your discovery meeting is next Thursday?
Yeah, yes, Your Honor, we have a conference scheduled at 4 p.m. on Thursday the 17th.
And some of
Judge, and I think from my perspective at least, having spent about a day and a half since our last court date going back through everything, from Ms. Gardner's standpoint, I need the index. I think a big problem here, going back through it cradle to grave, is that the state initially started listing every subpoena by date, and then they moved to generalities like toll records. Well, it's hard for me to know when I've got 6 different types of toll records for a certain individual, and I'm missing subpoenas for some of them, how that all matches up. And so I really, from Ms. Gardner's perspective, I'm really looking forward to the index so that I can cross-reference it with what I have, as I told the court last time, that I have and Ms. Gardner's team have sort of indexed and created our own sorting system to match it up and see what the state has on its end. And I have reviewed Ms. Day's detailed motion that she filed, and I agree with everything she said in there. That cross-references with our own list of concerns.
And from Mr. Fernandez's perspective, Your Honor, we echo those thoughts, as well as would like to just address, and at the discovery conference we can kind of get into the nitty-gritty. Today's probably not an effective use of time, but from the one specific example that the court asked this morning, the state responded that they would give us a printout and that would resolve it. But we just pulled it up again, and when you pull up the PowerPoint, there's a play button. We can't play it. So I don't know how giving us a colored copy change. I don't know what would play if it could play, and maybe their response is it doesn't play anything, and then we can look at theirs. But that, just to give you an example, that is what we're seeing, is that there's a play button. It looks like there's an animation of cell data, and we can't see that.
Okay. All right, so based on the motion to compel the responses, I think that, and like I've outlined in this order, which is pursuant to the rules, it's just a part of how this court normally presides over cases. However, I've given kind of like a more leeway, and I have not been as involved in the progress of these discovery issues, and it is what I have detailed, which is none of these issues are new. They have been there since the beginning. I know that the parties, which I've also detailed, that y'all have been working diligently, doing depositions of witnesses and things of that nature. However, there are a couple of things that I can see, at least from what the defense has filed and what the state's position is. The issues are lost in translation somehow. And I don't know, like if they say they can't open it and then the state's response is we'll just reprint it, that has been the issue. And it's also the subject of another defense motion, which is the duplicative nature of such a large amount of evidence. And that is what I want to avoid, okay? So this is what I'm going to do. You all have a meeting already scheduled on April 17th. You all should conduct that meeting, okay? And to the extent that you all can go through essentially each line item, that is the defense saying whether it's Ms. Day indicating that you don't have it, and then the state with your paralegal or whatever you're doing, that then you either have it or you don't have it. You all come back to the court, and I want basically a hold down list of things that you all are not able to resolve from this discovery meeting. Does that make sense? So you all are meeting, you can say we were able to resolve, and y'all keep working essentially from this document that has been prepared, that's been adopted. Are y'all with me? So if you all are able to resolve and the state has provided, then you all, in a discovery response, outline that. You all let me know what is still outstanding and what is not. That is a state disclosing, referencing the motion to compel by line item 27, whatever. You all have now resolved those issues, okay? So from the 17th, I'm going to give you all a week. That is all of the week of April 21st, okay? And then if you all have the time, we are going to sit down and have a hearing. I would propose May 2nd. And is the defense okay with the state's timeline on providing the electronic evidence? Y'all want it in 30 days, correct?
Judge, we want it as fast as possible. So
Right.
whatever the court, as much time as the court wants to give the state. We'll defer to the court.
Before I hear that motion, if the state wants to be heard on a different timeline than is requested, then I'll set that issue for a hearing. You can call whoever that can explain what's going on to me, and then I'll make the decision. Okay? But that will be before the 17th. so that that person can be working, or, so when are y'all available? I would propose on this motion to compel, we would handle on May 2nd the issue related to the disclosure of the electronic evidence. I could do it this week. Whenever, if you want a moment to try to contact your...
I'm unavailable the remainder of the week.
Okay, no one from your firm is?
This, depending on the day, Your Honor, this week, I can be available. Wednesday or Thursday, but that's tomorrow.
Would the state like an opportunity to contact the witness?
Yes.
See when he's available? He can, as far as I'm concerned, and what I try to communicate in this order is that I'm going to make this case a priority to resolve these issues as quickly as possible. I don't want weeks to go by, because if I let that time frame go by, that could be time that people could be working and they know what deadlines are. Per the discovery rules, I'm going to set deadlines. I'm going to issue orders, and those will be complied with, or you all can ask for extensions. And the attorneys will also make this case a priority. There is a rule that allows and mandates what calendar conflicts look like for the lawyers. The factors listed, which I put it, all these are just rules. I know y'all have filed all these motions, but these are rules that we should all just observe, right? If there are calendar conflicts, if there are schedule conflicts, they should be resolved in favor of this case being moved forward, because there are too many witnesses, there's too much evidence, there's too many issues overall. So if it's a smaller issue, I'd ask for some member of y'all's firm to be available, some member from the state to resolve these issues, and so we can move forward. I don't need everybody. Y'all can designate one to handle this court's ruling on how long it's going to take for this person to hash value, whatever you called it, like say how big certain files are. I'm going to listen, I'll make a ruling, okay? So somebody, small issues, I don't need everybody. I would like for the attorneys, especially on the defense side, like Ms. Day, for you to be available. Ms. Medina, if she's, I think she's on to help Ms. Peoples, if y'all are like dividing work that way, so that we can move these issues forward. The other thing I wanted to ask the lawyers about is that I think probably the like November timeframe, I brought up to the lawyers that I'm assuming, and I know that the defense has started filing some of the capital motions, but I did not see really any indication or designation by the state of witnesses that would be related to the penalty phase.
Your Honor, I'll just speak to the state in regards to the capital. I believe with the aggravators that have been enumerated, it's all contained within the facts of the underlying work.
Understood. But I also, like, if there are any disclosures related to, like, for example, this is all hypothetical. So let's say the state maybe anticipates adding further information, such as like a medical examiner that would testify even, so let's say it was HAC. That is not the case here, right? I would ask that the state be very specific, okay, about witnesses that may carry over, that may offer additional evidence that would be admissible kind of only in the penalty phase. Like, so you can put your straight evidence on in the guilt phase, but let's say, like, if it was HAC, maybe the medical examiner for prejudice reasons would not testify about the pain, the suffering, all of those things in the guilt, but they then are elaborated on in the penalty phase. So if there is a witness that would expand on information related to the penalty phase, then I think you should put the defense on notice. Additionally, if the state has done any mitigating investigation, the rules call for disclosure of that information to the defense. And I don't want it, I want it made big and bold, capital discovery, penalty phase discovery, so that we don't have any issues related to what has been brought up in the past. Like, I think Mr. Dreiser is the one that brought it up. He objected to how, like, a transcript was disclosed by the state. It needs to be, I would like for the state, as best you can, because the discovery rules not only say trial, but this trial has two parts, that you also disclose what you would potentially offer in a penalty phase. Maybe it's nothing, but I asked for that a long time ago. They have started filing their motions for them to then file additional motions that if they want to object, I'd like to handle those early on. Does that make sense?
Yeah, sure.
Okay. So, let's talk about the trial date. Does anybody think it's realistic?
Your Honor, I think we've had discussions off the record about moving the trial date, and I think we at least had preliminary discussions about the selection of a new trial date. I've spoken with the next of kin in this case, and they are understanding and in agreement with the new trial date that we had previously proposed.
What about the defense?
I would, on behalf of Ms. Gardner, concur with the state's assessment.
On behalf of Mr. Fernandez, I concur with most of what the state's assessment is, but would take the position, however unfavorable with your newest order, that until we see this newly organized discovery, it's premature to set the trial date.
All right.
Judge, if I could just go back for a second on the discovery, the joint motion to compel discovery. And I think the state, what I'm trying to understand is the state to file a written response before the court expects us to meet and confer, or after? I would prefer they file something before, so I know going into the meeting what their position is on each line item, as opposed to going in there and not having an idea of what their position is, or to the extent not having confidence that they have looked at all 207 items. Because otherwise it's going to be a waste of time and take us a long time if we're saying, hey, okay, let's talk about item number 203, and they haven't even considered item 203. So I just want some assurance before, and I think a written response is appropriate, before we dedicate the time and resources to go have this meeting, that the state has looked at each of these, formed a position on each of them, and then we can go in and we can talk about the position and maybe transfer items or have them show us how we can open things or whatever it may be. But my concern is that 1 week from now is a short time, for in my opinion, unless they're going to dedicate the resources to it, to get through 207 items and get a response to us or have an idea of what their position is on all 207 items.
The paralegal that y'all have working on it, how far along?
We've looked at each item on this list and at least have started. I have notations. I'm not ready to provide my notes to defense counsel today, but some things I'm ready to provide, some things I'm looking to find, and some things are, many of these are questions that don't involve provision of a missing item, but something I need to answer for them. Like how to open a Google, you have to use Notepad, that sort of thing. My concern is I don't want to file a written response until I'm certain the response to each item is what it is, if that makes sense. Because I don't want defense counsel taking what I provide to them, which they tend to do, in an email or a phone conversation and putting it in a motion later. Because I'm trying to provide it, information changes, it's fluid. I don't want to make a written formal response, sign it by the state saying this item doesn't exist because I'm looking at it now and I can't find it, but later I find it and then it shows up in some motion. I'm doing my best to assist them, and when I send emails and provide these items, it's in an effort to assist as quickly as possible. And in terms of filing a formal written response, I'd prefer it to be more accurate than expedient. But I'm happy to provide them information in an email, understanding that it's not the state's final written response before the discovery conference, and then supplement it with our actual formalized, corrected to the best of my knowledge response after our meeting.
And that's the problem, Judge, is that we never get finality with them. It's a moving target the whole time with this discovery. And so what we're trying to do, and what I thought the court's intent was, is that everyone is going to get locked in. Here are the issues. They're going to provide us a final response, and then we proceed forward. We cannot proceed forward if this is a continuous moving target. And that's what Ms. Stifler just told the court.
That's not what I said.
It's a moving target.
I'm happy to respond in writing. I just am not prepared to do it until we discuss some of these things at the discovery meeting.
What was, I understand. So let's say we never had this court date, right? Y'all had already scheduled this discovery meeting. What was the understanding? Because at the last court date, y'all said that you had the discovery meeting, I guess scheduled, and I was coming in before it, and I asked because that the defense formalize not in an email, which y'all did, and you did it within the time frame that this court asked. But this discovery meeting was always going to take place.
So, Judge, the discovery meeting was something that Mr. Khalil proposed in his letter that was going to essentially hit reset on the discovery process.
And I did ask Ms. Day to, and I'm sorry to interrupt, also, I asked Ms. Day these items that we've been going back and forth via email to number them so that the discovery meeting we could discuss them in reference to a specific number, and I could provide that information and then give them a written response to some of these items. So I'm not saying I'm not willing to do it. I'm prepared to do it. I just can't do it before this meeting because some things maybe we can work out that would clarify the response that I would put into writing. In terms of I can't open this item, I don't have the correct application, that might be something, or they're asking for things and they're citing at A3. I need clarification on where they're citing to before I can respond properly. So I'm happy to respond formally in writing, and I'm happy to give them an idea or speak with them or give them notes or an email of my initial review of this, but I'm not prepared to file a formal response prior to following up with them about some clarification issues I have in order to respond.
And Judge, we'll speak to the state. We have no problem meeting with the state. My concern is if the court's expectation is that we're going to sit down with them in a week and go through all 207 items one by one, that without us having a preview of what their position is, that's not, in our opinion, not workable.
How long is this meeting initially set for?
I think it's at 4 o'clock at the end of the day, so I would anticipate 30 minutes, an hour, is what we envisioned on our end. It was never meant to be a sit down and go through 207 line items.
What was it meant to be?
I think just an update as to where we are on Mr. Khalil's endeavor to reset discovery.
Why do y'all need to do that?
Judge, the idea behind it was to have regular discovery meetings monthly so that we could address not necessarily all 200 items at one meeting, but at least make attempts to go through and resolve every issue defense has. And knowing that we all have a specifically allocated time period every month to do so in order to keep track of all the requests in one place at one time with all parties present. This was just the inaugural meeting.
That seems like a waste of time. What is the most important thing that's going to move this forward on this list that y'all want an answer to?
I mean, all of it, Judge? I mean, I don't know. I don't know what the court means by move forward.
Meaning, so I'm assuming, maybe wrongly, that y'all still have depositions moving forward.
We don't have anything scheduled because...
Why not?
Because we have taken, I believe, most, if not all, of the civilian witnesses and several or many law enforcement witnesses, but we are now to the detectives and the agents that really participated in this, and I don't have confidence that I know every subpoena that was sent out and the return, that we have all the reports and their attachments. I just don't have confidence, and what I don't want to do is start a deposition, and that's sort of why we wanted the deposition of Detective Johns, is to go through many of the items that were on the list, and we did set aside a full day for that, to go through the items on the list and ask, for example, we have a return from AT&T for this number, but we have no associated subpoena. Where's the subpoena? We have a subpoena, but we have no associated return. What happened? We're missing the attachment to this police report. We have sub-reports through 164. Are there any more? Things of that nature. And most of that, if not all of it, has been, through great effort of Ms. Day, memorialized in this document.
All right, so at least at looking at this list, generally speaking, it looks like from the reports, I'm assuming, because looking at this list, there appears to be maybe one Jack's Beach report that appears to have some issue with it, that there's maybe part of it. There are computer forensic reports that I guess aren't working, and some forensic reports from Jack's Beach that are related to the electronic evidence, and the other part are ATF reports. I think just a glance at this, that a lot of maybe some of the issue would be that because the defense is missing, for example, an ATF report, the ATF report would let them know that whatever subpoena went out, did not come back in any type of return. It would be contained potentially in the narrative of those reports. And so the fact that the state has listed it because it somehow appears somewhere, but then the report would then answer the question. I think that you all start with the reports, that they cannot compel. Only the state can get unredacted copies of some of this information so that they can read it and maybe cross-reference that this isn't some mystery. I think a lot of it is because they don't have full access to some of these reports. And what is this online thing that they're referencing?
I'm sorry.
So are you talking about number 3?
Right. What is that?
So we found that on a public available website that was released by the state in a public records request. Much of the content we have, it's a different format than it was provided to us by the state. And there's a cover letter from the ATF that neatly organizes these reports. It was released by the state at some point via public records to the media, and now it is posted online. And it's this nice 250-page binder of collated ATF reports that was never provided in that format to the defense.
Do you know what they're talking about?
I don't know how the formatting issue, but I've looked into it and I can provide, that's ready to go, provide to them in that format now.
In the format that is online, but unredacted?
Yes.
Okay. How many total supplement reports are from Jack's Beach?
One moment, Your Honor. I'd have to look that up.
And has the state compelled all federal agents that worked on this case to get their work product? And are they willing to release it kind of unredacted for the defense disclosure?
Yes, they have not given me any issues releasing information to me. I do have a Zoom meeting with our analyst with ATF Friday to collect the entirety of her work.
What about Secret Service?
Secret Service was only involved in the extraction of the devices. Those reports are in the files provided with the devices themselves. The same way that JSO puts their mobile device extraction reports and receipts in their Celebrate folder, so does the U.S. Secret Service.
What is a receipt?
That's their version of the chain of custody property card showing that they received an item. So, for example, that would be something I would respond in writing, that receipt is referring to this document. They call it a receipt. We colloquially would call it a property card or a chain of custody card or receipt of property card.
Are you all still using evidence.com?
Jack's Beach, that is their case management
No,
system.
I mean, is that how y'all are
No, ma'am.
getting the okay, well, what are y'all doing?
In regards to this specific request, I'm going to file a written response and attach
No,
it.
I mean, how are they getting, how are you, like, example, like, so you are trying to give them these federal reports. How is that being delivered to the defense?
That's something I want to discuss with them at our discovery meeting, because I have them prepared. They can advise me how best to receive them. If they want me to open new files on evidence.com with an audit trail, if they want it on a hard drive, a disk, the physical document portion of the response, I'm just going to attach and scan in with the discovery response so that it's attached to the discovery response and clear.
What's the state position on, I guess, the appointment or deposition of Detective Johns? Are y'all still objecting to that?
To him being under oath and subject to questioning. I had told Mr. Carody and Mr. Hill in a phone conference that I had no problem having them come to Jacksonville Beach, sitting down with a property clerk or myself, my paralegal, and having Detective Johns available to answer questions or provide items as necessary. But again, my concern becomes when we're trying to answer discovery responses, that they're taking sworn testimony from him on, as we're trying to resolve issues that they're going to put later in a motion or a filing.
And Judge, again, that's the finality problem, is we're trying to move forward, lock the state in on what their discovery is for a case that they've been working now for more than 3 years. And they're still not willing to let their lead detective sit down with us, and if we ask him if something exists, let him be bound by that statement. And that's you know, that goes to the discovery here, where you're never going to move forward until we're able to lock the state in. And we have, Your Honor, just to let you know, we have at least from our position, we know that we have up to SUP 167 of the Jacksonville Beach Police Department reports. That report is dated September 11th of 2024. That is the last Jacks Beach Police report we have.
Hold on, give me the date again.
9/11/2024, SUP 167.
Let me ask the defense, Ms. Day, Ms. Medina, or Mr. Crody, the subpoenas that are referenced in that list, none of those answers are resolved in the reports that have been generated by Jacks Beach?
Correct.
So Jacks Beach is indicating that they've sent a subpoena and there is no resolution by narrative that there will result or no result?
Yes, but I would also say oftentimes the Jacks Beach reports themselves don't even indicate that a subpoena was sent. We're just finding subpoenas.
How?
Many were sent, they were all issued by the state, right? The state issued them. Some were sent by ATF, some were sent by Jacks Beach PD, some were documented in reports, some weren't, some we have returns, we have no subpoenas, some we have subpoenas, we have no returns, and I think that's a fair assessment of what we're looking at. I've been through this in detail recently, trying to figure out again where we are, and the state's first discovery exhibit, if you pull it up, Judge, they did a beautiful job of saying, here's the date that it was, there are some errors in that, but they did a beautiful job, listing the date the subpoena went out and who it went to. The problem is that was really the first year of subpoenas, and they have sent dozens and dozens out that are not listed in any discovery exhibit with that type of detail. And that's why we're looking forward to the index, to try and cross-reference to what we have identified.
What is the state's position on a deadline of this Friday to give the federal reports and determine from Jacks Beach if there are any reports past 167?
Are you referring to specific numbers or just in general any ATF and or Jacks Beach police?
So you said that is ready to go, so I don't necessarily think Friday is unreasonable deadline to basically produce this unredacted report that has been prepared through public records.
I can specifically tell defense in the court, I am fine by Friday to provide items 3, 4. Item 5, I just confirmed with Agent Bobby Blythe with FBI, there are no animations on these slides.
Why does it have a play button then?
I don't see I'd have to speak with Ms. Day, but I'm looking
Show
at
it to her.
the slides and I don't see a
Stop.
play button anyway.
Show her what
Put it
you're
on the
seeing.
screen, Judge, so we can all see it? Okay.
I don't know. Whatever she wants.
Well, it's-
I don't know. Yes, put it on the screen. I'd like to see it. Hook the computer into that thing. Go to the cart.
Yes.
For the record, I'm being told that's the ATF work analyst work product slide. I don't know what that means. I think we should get it. It exists. Because if it's work product that they intend to use, which I would imagine that's a real possibility. And even if they're not, we need
That's
a
fine.
response to that.
Mr.
So
Dreiser, I'll provide it. I just didn't realize that's what they were referring to. That's where, see, this is where some of the confusion is coming in. That was a slide provided to Mr. Dreiser and Mr. Hill at a meeting many months ago.
Has it ever made it to a disclosure?
No, because it was being prepared for trial purposes as a demonstrative exhibit, but I will provide it. That is the analyst that I said I have a Zoom meeting Friday with to get all her work product. I will provide that after I meet with her Friday.
But that's a PowerPoint. What number is that, Ms. Day?
What number in the motion?
Right.
It is.
Number 5.
Yes, number 5.
I can't have that by Friday because I have a Zoom meeting with her Friday afternoon, but I can provide that after.
All right.
I can provide item 6. I can answer question 7. I can provide item 8. Items 9 through 14 are going to be on hold because I think they correspond to the electronic evidence. And as I told the court, I'll have the detective come lay a foundation for the state's request for an extension on the provision of those items. Item 15, 16, 17, and 18, I can answer those questions by Friday. Item 19, I can answer that question by Friday. Item 20, I can provide by Friday.
Hold on. 15 through 17.
I'm sorry, 15, 16, 17. Yes, ma'am, I can answer those questions by Friday.
All right.
18, 19, and 20 are questions I can answer by Friday. 15 through 20 is just a clarification as to how things are categorized and labeled.
I can barely hear you, Ms. Stifler. You said what number?
Items 15 through 19. They're just confirmation and or clarification by the state. For example, number 18, photos of clothing refers to the 10 photos. Item 17 had been labeled JO DNA consent form.
Hold on. So does 18, these photographs, how does Jack's Beach categorize those? Do they put it in like a property card or like is there an evidence technician report that would document how many photos were taken?
Jack's Beach Police, unlike JSO, doesn't do separate property cards. The property section in their supplemental reports details what property is attached to that report. So for this example, in Supplement 123, they referenced photos of clothes taken from a garage at Potomac. There are only, defense says we only have 10 photos, none of clothing. The state's response would be the photos attached to that supplement are those 10 photos. There are additional photos of clothing, although they're not, this is getting into the weeds, but there are additional photos of clothing in a folder that the evidence technician had previously provided under evidence technician photos. They're just labeled photos of clothes in the supplement, but really by clothes, they're referring to the boots, the bags, the swabs in the door. For that specific supplement. Those are the photos attached to that supplement.
Can you pause? Have these witnesses been deposed already? Like the evidence technicians and?
Some of them.
So none of these questions were answered through the deposition?
Your Honor, if I'm not mistaken, there were 3 evidence technicians that we set. I believe 1 was taken, and if I'm not mistaken, the other 2 were having medical issues or were out of country, so needed to be rescheduled.
Okay. And have not been?
They have not.
Your Honor, with regards to those outstanding evidence technicians, unfortunately, both of the remaining Jack Speech evidence technicians were going through some serious health issues, and we just asked them to contact us when they reached a point that they were comfortable being able to have a deposition. So we're just using that, we're going to give them the necessary space that they need.
Okay.
And I think it's late in the game, Judge, but with everyone speaking, and maybe I'm just not remembering correctly, but I think when you came in, you just started the hearing. I don't think we did appearances for a clean record. Jesse Dreiser on behalf of Mr. Fernandez, Shannon Day, and Mr. Hill, who was just speaking. And for the times in which, on behalf of Mr. Fernandez's team, we remained silent after comments by the Gardner team, we would have spoken up if we had any disagreement or we didn't adopt those sentiments.
The evidence technicians that I guess y'all are holding on taking the deposition, are they the subject of some of these reports and I guess misunderstandings about what exists? Do you know?
I'm not really sure, Your Honor.
Okay.
The lead evidence technician was not yet deposed. They were set December 10th. One detective was on FMLA, one detective was not served, and one detective is having a serious medical injury and has left Jacksonville Beach Police but is in contact with me. So the Detective Jarman is the lead detective. He has not yet been deposed. The lead evidence detective.
The FBI, is that Agent Blythe?
Yes, Your Honor.
Okay. I think hopefully maybe to help facilitate, if you can get answers to these questions in written response. You've listed 3 through 8, 9 through 14, you're going to hold on that this court will hear. Then, but also 15 through 17, 18 through 19, and I stopped you because and it looks like going 20
I've obtained. 21 I can answer. 22 I can answer.
20 through 28, that's why I asked about the depositions of the crime scene detectives, because to me, some of these things may have been answered through deposition, but if not, obviously the defense is entitled to, whatever documents may be attached. So answer the question, I guess the state, to get an answer to these things that, let's say they exist or don't, let's say they exist, what form does the defense want it in? That evidence.com, or do you want it delivered in some other form?
I mean, to us, I would say the primary concern would be that it is provided to us in its original naming convention, which we've had difficulties with evidence.com. So that's the most important, and if the state can do that by some type of file share, then that's great. If they can and we need to provide them drives, that's great. If they want to provide us CDs, that's great. But I think the most important thing to us is that we don't lose the file structure of the naming convention as it's turned over.
Did the state ever resolve why, I guess, that delivery method results in them looking at something different?
I have not resolved that issue yet, Your Honor.
Okay. by Friday, can the state copy it over if they provide y'all a drive?
Yeah.
Copy over these items?
Right. The reports.
Yes, Your Honor. So I will, just to be specific, the state is prepared by Friday to provide items 3 through 8,
15 through 17.
15 through 17. And by provide, I mean I'm also going to answer some of these questions, but not in a formal response yet. I will send them an email with the understanding that that is not the state's final response, subject to any clarification we have at our discovery conference. 19 and 20, 21, 22, 23, 24. I need to, my parallels indicated 25, 26, 27. I need to clarify 28, 29.
Wait. 25, 26, and 27.
Yes, ma'am.
All right.
28, I need to speak with defense counsel and with the detective in regards to what specifically they're requesting for this item. So I'm not prepared by Friday. 29, I've provided everything I got from the West Richland Police Department. I would have to reach out to them to order additional supplemental reports if they exist, so I cannot provide that by Friday. 30 and 31, I can provide. 33, I can provide. And items 32 and 34 through 42, I'm in the process of following up on. So everything in the report section that I've outlined, I can provide by Friday. Some of these I can answer by Friday, and the other ones I've referenced, I can at least let them know it's being looked into.
I'm confused. Why don't you want to put it in a disclosure? The rules say that it's a continuing obligation to disclose. So putting it in a disclosure that it was provided, why do you, I don't understand.
I don't mind putting
the concern about that.
Putting in a disclosure the things I am providing. My concern becomes they're asking, some of these are questions. My concern is that I file a response in a response. So this isn't a disclosure. This is going to be a response to joint motion to compel discovery. If I'm not sure that that's, at this point, for example, they said there's an animation in the slides. I believe they're referring to the FBI slides, which don't have an animation. Until I speak to them at this discovery meeting, cross-reference with ATF, my detectives, and come back and we clarify, I don't want to put in a response under Section 5, there are no animations, and then have them file some motion for sanctions attaching a different slide that I didn't know that's what they were referencing to. That's my concern. I don't want to put it in a response pleading until I'm certain of the response. These are, for the most part, items that have been either provided or listed, and there's just clarifications that need to happen between defense and state. So I'm happy to give them information or an email or the information that is known to me at this time in regards to what I believe they're referencing. But until I'm certain of it, for example, 3, 4, and 5, I'm certain I can provide those. I'm happy to respond and list those.
What about the subpoenas?
The subpoena section is going to take me more time to cross-reference because I've provided them the subpoenas I've sent. I had listed them specifically at the beginning. The issue becomes when we're sending a carrier or a financial institution or credit union a subpoena, sometimes our records are non-responsive to our date range, or they're non-responsive, or they're rejected, or they request an updated subpoena. That's going to take me a little bit more time to figure out, and that's why the discovery meeting on Thursday, presumably we'll be able to speak about a little of this, but I can at least get most of this report section done, absent the electronic data on 9 through 14 by Friday, so they at least have that before our first discovery meeting.
Mr. Cleel, this index that the state is working on, your best projection of when it will be complete? I just need an idea.
My hope would be within the next 30 days. Our attention was diverted to responding to these motions to compel, because we knew that was a priority for today's court date. And so Mr. Taylor has been going through and addressing specifically the 200-plus items listed in this response. We have begun the indexing process, and so it's our hope that we will have that concluded as quickly as possible, but we wanted to be able to address and then file a response to the defense's motion to compel discovery, going line by line and having specific responses to either providing those information or clarifying there is no record responsive to Item 15, hypothetically. And so our attention was diverted to address specifically, because that was the court's direction, defense filed a motion to compel, and we're trying to address the motion to compel specifically.
Well, this is, if I were to recap, what became apparent to this court is that there have been, which it was attached to the, I think it was a sanctions motion. There were just a number of emails going back and forth between the parties. There are, like the state is saying, give us a list, and then it's a series of emails. So I wasn't telling the defense to but it's just not of record, it was my point. So there is no mechanism, and Ms. Stifler has said, well, the defense is filing sanction motions. Well, if this court is not involved in the discovery process, but for y'all saying that you're working, and I've not set any deadlines, I'm not involved, and y'all are just emailing back and forth, and then when there are issues, then what happens is there's a motion by the defense with a bunch of emails that I have no idea about. In order for me to properly manage this, like I said, the rules allow, and I should be involved in it. And I don't consider it, quote unquote, the weeds. It is, I need to be involved because y'all are not on the same page. And it's important for me to get the parties kind of on the same page, working from the same information. And so that is all I was saying. It's not documented. I didn't know that there was an agreement about DNA. That is not of record. And so now it is. I'm going to grant it. Right? Y'all didn't have any objection to that. No. Correct? So I'm going to grant it. So this is, as far as a response, y'all do what you want related to how you want to respond, but the response needs to conform with the rule. I am going to require that. So if you do respond that it is what it is, it needs to be categorized. It needs to per the rule, okay? Not just, I don't know. It needs to conform with the rule. The rule, I think, would solve a lot of these issues related to what the defense is objected to, which is kind of, I think y'all call it disorganized. I can't remember what. So the rule organizes it. Any response, the defense from the state should not leave them with the responsibility of what category to put it in. So the state, in whatever your response is to their order to compel, which I'm going to grant in part, and I'm going to leave part in abeyance, and I will set the other parts for a hearing to determine a time frame that is reasonable, also keeping in mind that this is a priority case. So it is the state's obligation, it's the state's responsibility to categorize it for the defense so that they know what their ability is per the rules, or whether they need to seek court intervention or not. I would ask that the state, whatever you decide to do, that you comply with 3.220. That, I think, will help organize everything. And to the extent that we can, I guess, get a response prior to the meeting by Friday, that would give, I guess, about 3 to 4 working days for the defense to review it. Then hopefully that looks like about a quarter of what has been requested by the defense. I can wait, or I can intervene now, put deadlines on the response on the subpoenas, so that you all can, I guess, the state can respond whether they have it or not. And then we all come back together on May 2nd. You know, but just looking at this list, it doesn't make a whole lot of sense that, you know, some of these things are more than 2 years old, whether the state has it or not.
In terms of the subpoenas, it's not that we don't have it, it's that what we receive from the institution we subpoena is not always, for example, if I send a subpoena that asks for a specific time, date range, they've received whole records, as have I, from that institution that aren't necessarily responsive to that range. So they could send records from a different date range, or a wider date range, or a shorter date range.
Well,
it's just a matter of correlating it for them.
I will, let's put the subpoenas to the side for a moment. Let's talk about the receipt from Ruby Tuesday that was disclosed on November 15th, 2023. Like, whether y'all had that or not, to me, you should be able to respond to that, right? That doesn't take anything other than the state determining with the law enforcement or a copy of it, right?
Yes, ma'am. I said
Okay.
items 34 through 42 I should be able to provide. It's just a matter of,
So let's put the subpoenas to the side for a moment. There are a lot of them. What about the photos, videos, media? Those were disclosed in 2022.
yes, ma'am, I'll work on providing. I know certainly some of these items are contained within the ET, at least in terms of 157, 158, are contained within the ET photo disc that was previously provided.
The DVD of the flyover, does that exist in their property room? 163.
Yes,
Are these like DVDs that just need to be copied?
most likely. I
All right,
can get
Friday.
that done.
Friday. These USB things, you're saying it's, was it somehow uploaded?
Can you give us, are you talking about?
Like 175?
Yeah, so.
Was that uploaded to something and came down?
So that's how it's listed by the state, and our question is, we don't have a folder that's titled that, so what is it?
All right. Okay.
I mean, the old days, you'd get a disc, right, that said USB drive containing video, and you'd be like, okay, that matches with the discovery exhibit. We don't have a folder or a file name with that.
All right. The defense, y'all go get a hard drive or whatever y'all have or whatever. I don't know what, maybe y'all can talk offline about an ability to transfer these things, provide it to the state by tomorrow. Let them go out there and have somebody in the property room copying some of these things.
Yes, Judge.
All right? I'm obviously not familiar with the evidence.com. I'm not sure why y'all can't, I guess, get the disc and pay whatever fee they require, or give them hard drives or whatever y'all need to get it duplicated. I don't know what the easiest way to be. I'll let y'all talk offline about that. Like if it's they tell you disc, but these things should just be in the property room, and someone just needs to go over there and copy it. They're like, don't have, and I don't know if it's a function of it went up into that cloud and it came down and a bunch of numbers that they can't verify, but let's just copy what is in their property room by Friday.
That's fine, Your Honor. That's exactly what it is. The way I labeled it in the discovery was how it's labeled in the Jacksonville Beach Police reports. So at the supplement, it would say USB drive containing video. It's attached to a specific supplement report. I can give them that supplement report number. It's been provided through NextPoint and now evidence.com. And presumably it's just, as Mr. Carodi said, a naming function. So I'm happy to
Let's just
go to the property room and re-copy it.
just copy it
And then
from whatever they have. If it's a USB, give them a USB and transfer it onto whatever
Yes.
mechanism. I'm not going to dictate that, but things that have been in the Jacksonville Beach Police Department's property room, give them whatever mechanism, whatever y'all come up with, just copy it and not upload it. So to me, that is a simple solution, and then y'all can detail it the way that you want. These interviews, I will hold that. to get some type of bearing on if it does exist in recording fashion, how do they keep those?
The interviews are on discs, but the interviews have been provided. Most of what they're citing here, some of these do not have, they're just asking if there are recorded audio or visual or recorded statements of these people, and some of them there are not. The state did not record anything.
The information from the news, the state is cataloging that?
Yes, ma'am, that came out during deposition of those witnesses, and I did send all of those items via email to defense counsel previously. I will put it on a disc and attach it and reference it to this response. And I'll reference my prior email that sent those items.
And the jail calls?
The jail calls, I'm working in conjunction with Gardner's other motion filed for specific discovery.
Okay, I'll hold on that.
Yes, Your Honor. But the jail mail, items 203, 204, 205, I'm sorry, 204, 205, and 206, I can provide. I have those.
203 through 205? That's
I'm sorry, 204, 205, and 206.
All right.
They have received a certain number of jail mail, and I will respond. If we have additional jail mail, I will provide and confirm the number of letters.
Okay. Can y'all get the disk or hard drives by tomorrow and provide it to the state? However y'all...
Yeah, I mean, it depends what size, but generally, yes.
Okay, well, y'all talk about those numbers.
Yeah, I mean, I think
that means nothing to me.
Yeah, I think we're talking about a relatively small amount
Right.
of data as opposed to, you know, the terabytes that exist in this case. So, yeah, I
Right.
think the answer is yes.
Okay.
You can get them a device.
Are y'all available the week of, I said May 2nd, what about April, are y'all available the week of April 21st?
Your Honor, I'm out that week.
Oh, you're out.
Yes, ma'am.
When are y'all available April 28th?
Can be available 20 minutes to the second round.
What about the defense?
The 30th, the 1st, and the afternoon of the 2nd.
I am unavailable the afternoon of the 30th. However, if that's the only date that works, I'm sure Mr. Hill and Day could attend. I'm
All right.
available all day on the 1st.
What about April 30th?
In the morning or Ms. Day or...
Morning. Morning?
Available that morning.
Yes, Judge.
Yes, Judge.
You know?
All right. Do you know if your witness is available?
I have one moment, Your Honor. I texted him, and I have not heard back yet.
That, so it's the 8th now. If I go to the 30th, that's essentially 30 days. Almost.
And just, we have no intent to cross-examine the Secret Service guy on this issue. If the state wants to provide a declaration to the court, I'm just throwing options out there with regard to the witness as far as how much time he would need.
Well, the defense has asked for 30 days. If you don't object to longer,
No, we do object, but if the
Okay.
court is going to find good cause,
well, I need to talk to him. I don't know. I'd rather do that shorter rather than later, because if I pass it all the way till then, I mean, it's an ATF agent? I thought it was somebody from JSO.
He is cross-sworn with the Secret Service and JSO CFIU.
Okay,
He works for the Jacksonville Sheriff's Office and is cross-sworn with the Secret Service.
okay. Well,
He's generally very responsive. I just need today to get in touch with him, get an idea. He might tell me otherwise. He's begun the project. He might be able to give a shorter deadline. I just haven't had the chance to speak to him since originally 2 weeks ago, giving him the device requests. I can.
all right, well, I'm going to set it April 14th for hearing a motion to be set, and then you can get with your witness, and then y'all can let me know that you got the devices, okay? And then I'll set it from there.
So no, we're not setting the 30th.
No,
Judge, did you say so we can tell you whether we got the devices?
no.
Okay.
Well, yes, like, you're going to give it to them, and they're going to give it back to you, copied.
Yes, okay.
Whatever, I don't know what method, I
I don't know. I was confused because the detective is talking about devices as in...
No.
Yeah,
I'm not talking
okay.
about that. I'm talking about when you, in my mind, when you've got a lot of information, you just break it down into small, usable pieces. So
Yes, Judge.
what we can do, we're going to do. And then I'm going to check and make sure it's done. And then we're going to go on to the next issue. And then I do want an answer. The case is currently set, and I know, Mr. Dreiser, you think that it is premature. But when we all know what dates we're working towards, to me, we can spend, the remainder of this year working through these issues. We have not even gotten to the substance of this case. Y'all have not gotten to, a lot of the substance of the case. Maybe y'all have been working around, and I understand why, as complete as we can get this discovery. And I also I think it's about the time that Mr. Gano needs to file some type of report too.
So I do have an update on the court on that. We did receive a copy of a UFED report for Miss Gardner's iPhone. We have reviewed that. We found it in our review to be appropriately redacted, and we have given Mr. Gano essentially our findings, and he has indicated that he's going to move forward and provide.
I need you to document that. So,
right, Judge.
like without objection.
Right, okay.
You see what I mean? To comply with the order.
Yes, Judge.
Y'all have the time to review it.
Yep.
And then you need to say, whatever report he has provided has been reviewed, no
I
objection to
understand,
disclosure.
and I accept responsibility for that shortcoming on this occasion.
No problem. I just, we've actually made some headway.
Yes, Judge.
Which is good, okay? So,
And Mr. Gano's advised the state he's begun working on Mr. Fernandez's Google returns, so he'll...
great, we're making some headway. That's wonderful. But in order for it to move forward, Gardner has to indicate to the court that it's okay for disclosure, then I will okay the disclosure because you're the only one that has it. So then it goes back to the state, to Fernandez. So we're moving, which is incredible news in light of where we've been in the past. So that's wonderful that at least that is moving. So as soon as you let the disclosure...
I'll file that today.
Okay. Then I will issue an order allowing disclosure per the, I think it's the second amended order that I did, okay? All right, so my thought is that you all start looking at those dates, okay, that I previously communicated, because it takes, it will take a lot of planning and coordination consistent with the order that I put into place and the factors, and that we start working toward a new date, because October is not realistic in this court's view. All right, so I'm going to give you all until we meet again to finalize what y'all think about it, okay? Do you want me to repeat the dates back? That would be proposing.
Sure.
Do y'all have it or no?
I'm just going through my notes. Just
The trial date, Your Honor? January 20th,
Through?
March 13th.
Correct.
And what are you asking us to confer on as to whether that's realistic or that we're still available?
Look, with you all, I have to book early and often, so I want an idea of what y'all have going on in that time frame. At this point in time, I would think that because there is a trial date that y'all have blocked off that time, instead of taking time that I know that we are not going to make, I would unblock that time and move this case to a different date, is my thought. So there was in setting that, I was not anticipating that the Gardner team would be unavailable during that time frame. So what I'd like to do is reset and everybody start working towards that date, blocking those dates, giving this case the priority status that this court has now ordered on the new date. Because right now, it's April. The case is set, 6 months from now. What is it, Mr. Dreiser?
I thought I understood the new date meaning the January to March dates. You're not suggesting that we come up with a new date.
No, that we work towards that date.
As I sit here, having listened to this entire hearing, that seems, even though it's, the next winter, spring, it seems unrealistic to me. So I was wondering if you were asking us to confer on blocking new dates, but that does not seem to be what you're asking, so I understand what you're saying.
Well, right now, because I have not moved, October is what I was asking y'all to block off, all the way almost to the end of the year. And so which I believe the last estimate by the state, I extended that period of time that I asked y'all to block off by, I believe, 4 weeks, to give the parties plenty of time. I don't know what any of this would look like in a trial sense. I do know just procedurally what, depending on the jury's verdicts, what the defense would be entitled to, the court's position would be as much, and when I tell you as much as I possibly can, I will have both juries working. And I'm putting it out there now that we're talking about discovery, right, that the state needs to think about, which is both juries working. That would mean that you would have to duplicate some of this evidence in both cases. So if both juries can be working / deliberating, that they are both able to work / deliberate. So as much as I can overlap them with as little downtime as I possibly can for one jury or the other, that's what needs to be done. While one case has been closed down, that jury is working, the other case will be closing down and working, and as much as, and they could share potentially physical evidence, but photographs and electronic evidence and all of those things should be duplicated so those juries don't have to be down, that they could all be working kind of simultaneously at the same time. And that's what the parties need to think about additionally for scheduling. And I'm just putting it out there so that y'all can give me, y'all know what it is, I don't, right? That how you all, if it becomes necessary, how you all would choose to operate, right? Meaning that if there are, like, defendants are entitled to 2 separate penalty phases, how y'all would work with that, whether you want that or not. So those are questions when I'm scheduling that I need answers to, so I can give y'all realistic timeframes, and I'm not just blocking off time that may or may not be needed, but I also need the parties to be realistic about the rights, that the presentation of some of this evidence. So those are the things that I want y'all to kind of discuss amongst yourselves about how much time you would be asking to reserve, so that I can give y'all the time that you need. And I would always have like a buffer period. I'd rather reserve it and not need it than try to have people scrambling around, you know, when you have other things planned. So that's what I want y'all to discuss between now and the next time I see y'all, okay? Okay?
Yes, ma'am.
All right. April 14th, 9 a.m., hearing a motion to be set.
All right. You heard the judge. April 14th. Let's get to it. This is a shorter one. So it was 2 hours, then an hour and a half. This one's only an hour and 15 minutes. And I think, Selena, I think you asked earlier, you hope that there's more. We have 1, 2, we have 3 more. We have 3 more pretrials to go through before we call it a day on this stream. And then don't forget, later we're going to do Courtney Clenny. She was back in court yesterday. Ooh, sorry. Yikes. She was back in court yesterday, so we're going to show Courtney Clenny's hearing from yesterday. So stick around for that. All right, here we go. Oops, hold on a sec. I do like the audio in this this courtroom, though. Thankfully, we have good audio. All right.
Judge Cook presiding. You'll be seated. Morning, Your Honor.
Thank you. Good morning. Good morning.
Good morning, Your Honor. Christina Stifler on behalf of the state. We're here to address the cases of Mario Fernandez-Saldana, number 4 on the court's calendar, Shanna Gardner, number 5.
All right. Good morning. If the defense could put their appearances on the record, please.
Good morning, Your Honor. Shannon Day on behalf of Mario Fernandez, along with James Hill and Frank Sony.
Good morning, Your Honor. Patrick Rody and Jose Baez, who's on Zoom for Shanna Gardner.
All right, thank you. All right. So tell me how it went with the disclosures or copying of the information that was due by Friday.
Your Honor, I provided the hard drives the defense provided to me, I provided back Thursday afternoon. They have signed an acknowledgement receipt that all the items that Your Honor ordered were provided. Other than anything that was a question to be answered, I told them I'm available to answer those questions at their convenience. But all of the actual items that needed provided have been provided, as well as the supplemental reports from the Jacksonville Beach Police Department. I spoke with ATF, and they'll be providing any supplemental reports if they exist this week.
Okay. And the one thing that was online, was that the unredacted, the 250-page?
Yes, ma'am. So what that ended up being was a true crime blogger got a public records disclosure from a media article and posted it the Public Records Department had done redactions. It was just a consolidated version of all the ATF reports that had previously been provided to them, along with I had it in a binder with a cover sheet and tabs, and they had photocopied the cover sheet and tabs that I used. Your Honor, we have a discovery meeting with Defense Counsel Thursday to answer some of these questions. I am working with my paralegal on the missing and/or correlation of subpoenas to records received and search warrants outstanding. I do believe we'll be able to resolve almost everything on the list they provided. There are some questions that I think I can answer for them on Thursday. Where we are at now is I have Detective Shannon Padilla present from the Jacksonville Sheriff's Office and Secret Service to explain to the court the digital evidence, the extractions in specifically Defendant Gardner's motion to compel digital forensic data. He is here, as Your Honor requested, to lay a foundation for the state's request for more time and/or, at this point, a priority list from Defense Counsel for Ms. Gardner, given the amount of data that they're asking to receive.
Okay, before we get there, I want to make sure from the defense perspective.
Your Honor, we would say we got about half of what we were supposed to get on Friday.
Okay, well, let me go back then. Mr. Hathaway, could you print the motion to compel? Give me just one minute. Do you know what docket? It's on Defendant Fernandez's docket line, the one with like the 200. Could you print that for me again? Just the motion with the list. Give me just one moment, Ms. Day. All right?
Yes, Your Honor.
Thank you. All right. Didn't go through. No, it's okay. All right. So tell me, from your perspective, did you y'all provided the hard drives, I'm assuming?
Yes, Your Honor. I believe I dropped it off after court that same.
Can you get closer to the microphone? I can barely hear you.
I dropped the external off at the state attorney's office after court last time, the same day. We received the download on Thursday of last week. There were some folders that we were not able to open.
Okay. Well, tell me which ones.
Well, we did get a different download from Ms. Stifler this morning that I think resolve that issue. But for instance, the first item, the unredacted copy of the 250-page ATF report, we got a 233-page report, and the cover page is different.
What number was that? If you could go by number.
Yes, item 3.
3, okay. Okay. What's next?
Item 5, the ATF cell data animated PowerPoint. The PowerPoint in question, we have, as it appears to be an 8-slide PowerPoint. We received a single slide in response, and I don't believe it's the same map or report.
All right.
Item 15, the OSCR 360 photos. We received the same 4 diagrams that were previously provided, and I believe those are the same 4 diagrams that were also provided in response to item 157, which is the Faro diagram, and item 158, which is the ET diagrams. And I guess it's twofold problem. One, since we got the same 4 diagrams in response to all 3 items, we don't know which is which. And as it pertains to the Faro diagram and the OSCR 360 photos, we think we should have essentially the data that goes into the making of the diagram. We believe it's the laser mapping of the scene.
What ET created this? You don't know? You're not able to cross-reference what witness would have done this?
If I had to guess, I think Jarman, but I'm not positive.
All right. Okay.
Then item 22, we got an 8-page attachment, and it is unredacted compared to the attachment we previously received, but the one we previously received was 6 pages, and the one we just received was 8 pages, so we just, I guess, need to confirm how long the correct attachment is and whether we have it.
Okay.
Item 23, there was no response. Item 24 should have been an attachment for John Biggerstaff's Regions Bank response. And the report specifically states that it's a subpoena return from Regions Bank for Biggerstaff for May 22nd through November 22nd. And the documents that we received last week were from January 2022 to April 30, 2022. So they're not the right documents for that report.
So, tell me what the report says again. It's
the report says the subpoena return from Regions Bank is for Biggerstaff,
right.
May 22 through November 22.
May 22 through November 22?
Yes, Your Honor.
And then you got January 2022 through what?
April 30th, 2022.
All right.
Then for item 25, that is supposed to be an attachment to supplement 162, and that report states, I received a subpoena return from AT&T for John Biggerstaff's phone covering March through July 2022, and I believe we got 5 different subpoena returns on Thursday as this attachment.
So what's the problem there?
It should just be one return.
Is it for those toll records?
Yes.
Is it a different date range?
I believe that date range is included. I guess that just more goes to we're getting duplicative, more of a data dump than a specific response.
Okay.
Then item 27 is supplement 164. It should be attachment NFCU return for Gardner and Fernandez. And that report states, I received a subpoena return from Navy Federal Credit Union along with explanations as to why some documents were not given in the returns. Again, it appears that we received kind of a dump of all of Ms. Gardner and Mr. Fernandez's Navy Federal Credit returns, and I did not see anything that seemed to be from this return or any explanations.
And so you're saying you got
Your Honor,
just
I think what just to sort of explain what Ms. Day's talking about is that we are getting all of the records that we've already gotten again, whereas 164, the narrative is, I received a subpoena return from Navy Federal Credit Union. We don't know which one was received on this date of this report, which is January 16, 2024, along with explications. I assume that that's a typo and they meant explanations as to why some documents were not given in the returns. And one of the major concerns that Ms. Day and I had going through this is, where is this explanation document that they received or letter that they received from Navy Federal that has these explanations as to why some documents were not in the return? And it says a copy will be placed into property.
So in response to 27, you got a duplicate of records that you already have, but you're missing the explanation.
Right, and the records, I mean, Judge, if I could, there are duplicates upon duplicates.
Okay.
The records are mixed in with each other in certain PDFs. I mean, you know, it bounces from Ms. Gardner's to Mr. Fernandez's to the trust back to Mr. Fernandez. And if that's the way they were received, okay, I got it. But we don't know that because they're not being provided to us what we believe, you know, in the form that they were received from NFCU. Maybe they are, okay, but there's clearly some explanation document as to why some documents are missing, and we don't have that either.
Okay.
And
what witness would this relate to, 27?
John.
the report was written by Detective Johns.
Is there a witness that's listed for Navy Federal?
I don't believe so, Your Honor. I think if anything, there may be a Category B that has a custodian of records.
All right. All right, Ms. Day.
The next one, item 156, the DLE surveillance clip. I anticipated that being just one video, considering we only have one FDLE report, which is for a review of a single video. But on Thursday, we received 323 videos.
Oh, Of what?
A mishmash of surveillance, ring videos, Nest cameras, things like that.
Whereas FDLE in their report talks about a specific video, 1800 to 1900, Fed 16 driveway camera, 49.21 truck.mp4.
And you don't know whether that's contained therein, what was disclosed?
I have not gone through the 323 videos.
And I think our point is, Judge, is that they're just dumping things on us without making an effort on their side to be responsive to our demand.
So, in the order, I wanted you all to get what was, at least according to the documents that have been filed, in the property room. So I gave them time, that is 5 days, to categorize and update the discovery. I don't think the 5 days have expired at this point. So what they provided to you, they should be documenting, and the order was for them to categorize them pursuant to 3.220. Do you see what I'm saying?
Judge.
Like, I wanted you all to be able to get whatever, in going through the list in the compel, some of these things, for example, where it says SDE, which stands for State Discovery Exhibit, July of 2022. So y'all, in my mind, should have had this 3 years ago. So I wasn't expecting necessarily that it would be categorized. I wanted you all to have the information. They had the time to categorize it at that point in time. If they needed to update, they could update. But what was sitting in the property room, I didn't want it just sitting there. I wanted y'all to have the ability to have it. So I think is some of this new to you? The fact that there are 323 videos?
This information they're telling me is new to me today, and all they had to do was call me and tell me. I had them come Thursday, the idea being, I didn't want this to happen, make an appointment with my paralegal. He did which is going to be part of my filing, actually organized each response based on what we pulled from the property room, exactly as it was in the property room, by the number corresponding to their list, for them to click on each folder in the presence of my paralegal, verify what was there. There was one video from Walmart that wouldn't work. They all spoke via email. They signed off, both Ms. Day and Ms. Peoples at the bottom of this sheet. I heard nothing otherwise to indicate that there was any issues or problems that they're bringing to the court's attention now in open court. So I have not categorized or done the disclosure or the filing yet. From my perspective, I heard nothing. I got a signed receipt saying I received all these items, other than an email alerting me a Walmart video didn't work, so I brought a working copy this morning. So I'm sorry I can't respond to this right now. This is a surprise to me this morning.
Well,
but I will say to the court, what they've been provided, my paralegal and Detective Johns actually pulled the property clerk from Jack's Beach property and copied as is what was listed and attached to each supplement. The FDLE surveillance clip, when I looked at the folder, it was organized into subfolders which showed the clips that FDLE had made, and I believe he included the full videos that they pulled the clips from, just for reference. It's not meant to be a data dump. It's meant to be a completion of discovery. Number 5, they received one slide. They showed me one slide in court Friday. I had no idea that there were additional slides they were requesting. So I'm going as best I can off their list, and I'm going off of the reference reports for Jack's Beach Police. So I think this could be all solved if we just have a conversation or discuss this at our Thursday hearing, our Thursday discovery meeting, because I think there's some things where I could easily clear up, like the Oscar 360 diagrams. Those 4 diagrams are what we have. That came straight from the property room. If they have other questions, I'm happy to answer them Thursday, but I will file the disclosure listing anything that wasn't previously provided and/or read.
Hold on. The FDLE, what unit is this? And
it is the video, I don't know the technical term for it. FDLE has a unit, and they were able to take surveillance video from the scene from various Ring cameras, Nest cameras, surveillance cameras, and make attempts to basically zoom in, lighten it, augment the video so that it was more visible in order to identify the shooter. So it was more so just kind of a technical editing to make it more visible.
All right, and this, I'm assuming the 323 was not disclosed that way. The 323 videos.
I will have to look. All the videos were previously disclosed because those are the surveillance from the scene. I can disclose specifically the video clips that are in the subfolders in the folder they've been provided. It was more, and to be honest with the court, it was for investigative purposes that we did the video editing. At the time, we did not know the identity of the shooter. I don't know what, I mean, there are discovery purposes to it, but it was truly an attempt to identify the individual that we see on scene committing the homicide before we knew who it was. So it was an investigative step that we did.
Okay. Well, let me finish the list with Ms. Day.
Yes, ma'am.
We were on 156. So there were 323 videos.
Yes.
And the time frame was 1800 to 1900. You thought it was one clip?
I know it was one clip. The report from FDLE says they received one clip via email.
Okay. Okay, keep going.
Then we kind of already talked about 157 and 158 are the same as, I think it was item 15, the Oscar 360 photos. There was no response to items 160, 161, or 162. Item 171 was a surveillance video from 4021 Palm Way. We have not gotten those ones to appear. It just appears as black and white static. I'm not sure if it's that way on the state's end as well, or just ours, but that video we have issues with.
Which number was that?
171. Technical issues, like you open it up and it's nothing, or it just appears to be like?
It just shows as black and white static.
All right.
I believe we received 176 and 177 via a flash drive this morning, though I have not had a chance to go through them.
176 and what?
177.
Okay.
No, I'm sorry. 176. We got 176 this morning, not 177. We got 177 on Thursday. But Ms. Stifler's assistant, Mr. Taylor, indicated Detective Johns could not recall what ESST stood for. So we got 155 surveillance videos, and we believe that they're duplicates, but I suppose we still don't actually know the purpose of them.
So you did get a response to 177 and it's 155 videos?
Yes.
All right. All right.
178, which should be the Snapchat clip of scene provided by E. Frauenheim. We received a screenshot of an Instagram post as opposed to a Snapchat video.
Is it Instagram related or no?
It is an Instagram post. I don't know why it's labeled Snapchat.
So that needs an amendment?
Yes, ma'am.
Okay.
Then there was no response to 179.
There is. On your hard drive, we included the last file, prior email regarding 179 and 180.
That's the question.
Yes, ma'am.
179 and 180?
And again, as I said, I can't provide something that's not tangible, so I did let them know that I was prepared to answer the questions. Nobody followed up. So I'm prepared to answer the questions. There's no ability to put that onto a folder. As far as 160, 161, and 162, there are none. There were no photos taken of those items, of the fingerprinting.
So 160, 161.
And 162, there are none further.
It says it was in a previous discovery download, is that not right?
There are no further media release images. We disclose the 3 that exist.
And when they're referring to photographs, are they talking about like latent print cards, or is that
Yes.
captured different?
Much like JSO processing, they don't, at least in my experience, there's nothing to photograph when they're processing the fingerprints. I'm certain that there are fingerprint cards, most likely, that when they depose the person who's doing the fingerprint, they could provide those, or I can request those, but there are no photos. They don't photograph the latent print cards.
Ms. Day, what were y'all expecting? Do y'all just want to inspect it if it exists with an expert?
Yeah, I had kind of just thought that there would be a photograph of a print collected. If that doesn't exist, it doesn't exist, but...
No, it probably exists in a different form, I guess is what... If it's similar to JSO, it'll be a card, and then the card remains with property.
They wouldn't photograph fingerprint, unless it was like a bloody fingerprint or something on a scene, there'd be a photograph, but just regular latent fingerprints, they don't photograph that generally, but there will...
Did you want to inspect it?
We may ask for that, yeah.
Why don't you clarify then, instead of no response, okay?
Yes, Your Honor.
Well, I'm telling the state to clarify. If it's a card, it's a card, or if it exists
Yes,
with the expert.
And I'm not trying to overstate this, but again, if we all speak Thursday and I'm able to file the state's response as required by the court, I think a lot of this will be cleared up.
Right, I just want to know when you all do respond,
Yes, ma'am.
that it's either resolved or we need to move forward. So,
We were at 178. Are there others?
I don't see a folder for 179 on my external, so
It's not a folder, it's an email. It says prior email regarding 179 and 180.
Okay, I just didn't scroll far. Okay, so I do have that one. Then 181, the body-worn camera from Henry Tennant's arrest. We received 2 videos from January 25th, 2023, but he was initially arrested on August 18th, 2022. That footage has been sent to the media, and we did find it or a clip of it on YouTube. So that is the footage that we're requesting.
Okay. So his arrest on the DWSR, not his arrest on the homicide?
Yes.
what are tire stains?
There was staining on a tire left in a road that was photographed and swabbed.
Did y'all?
I'm sorry, not well, I don't know what was in the folder, but there was
Okay.
ET photographs of the tire. I don't know what she meant by stains. The stains were swabbed and sent for processing.
All right, y'all got that?
Yes, Your Honor.
Okay, what else?
I had marked 185 as a video that we could not play, but I did get it via flash drive this morning. I just haven't had a chance to open it and review it.
Okay,
And then I had marked 186 as we received 69 videos, but I was not able to get them to open or play.
so you believe you're missing one? It says 70.
Yes, so we're probably missing one, and still having trouble opening.
All right. Does that conclude it?
Yes, Your Honor.
Okay. So what I'm going to do is I'm going to hold and see what you all are able to resolve as far as this meeting that's going to occur. To the extent that the state can, I guess, maybe amend some of the things and have it prepared prior to your meeting on Friday, I think it might help clarify some things. For example, if it's mislabeled, if it's, like if you call over there and you say, these aren't photographs, this is a card that exists with, as much as you can clarify, because I think that, if I'm hearing Mr. Carodi correctly, he wants to be prepared, Ms. Day wants to be prepared for what they're, I guess, going into, and they should be prepared saying, this is what we're missing. And then y'all are going to work on the remainder of the list? Is that how it's going to work?
Yes, on Thursday, I want to discuss with them,
Is it Thursday or Friday?
our discovery meeting's Thursday.
Okay.
Specifically, the subpoena returns, the way that the documents are being tendered to them is the way that we receive them from the bank. Mr. Fernandez, Ms. Gardner, and her trust, they were all on accounts together, so the accounts are mixed together. I didn't just throw them in a pile and photocopy them that way. That's how I received them from Navy Federal, Regions Bank. The biggest lift for my side, as I told the court last time, is going to be to try to correlate for them the responses we received based on the subpoenas we were given. Because we sent subpoenas multiple times to the same bank because they were not responding to our date ranges, or they were sending non-responsive records. So it's not just a discovery problem, that is how we received it from the bank. If I have to list somebody from the bank and make them available for deposition to testify from their end about how they receive records, how they keep records, I'm happy to do that, but that's going to take me some time. I can't do that, like going to the property room in 5 days was fine, but it's going to take a conversation between us and defense counsel, which is why I think Thursday will be helpful. We're not going to be able to solve it Thursday. I don't want to give the court or defense any false expectations there. I'm not going to be able to sit in an hour and line by line match up a subpoena return to a subpoena for each one of these bank records, but I can certainly get from them an idea of where their confusion is. Questions like, this subpoena is attached to this supplement, it has this date range, and we have records for X date range. Some of the explanations given were because detectives are calling and following up, so there may be letters of explanation, there may be information they received via telephone. I can help put on notice defense if there's information that they need to ask the detectives about at depositions regarding any conversations they had orally with any of these custodians or people from these financial institutions, cell phone carriers, etc.
Okay. All right, let's, you have the detective here on the devices.
Yes, Your Honor.
Okay,
You want him to step forward?
yes. Good morning.
Good morning, Your Honor.
Detective J.S. Padilla, P-A-D-I-L-L-A.
All right. So the reason why I asked that you come to court is that the state, I believe you asked for 60 days.
I'll let Detective Padilla speak to that. Judge, I have spoken with the detective, and we have reviewed Ms. Gardner's motion to compel digital forensic data. What has become clear to me, having spoken to their expert via email and speaking with Detective Padilla, is that they are requesting forensic imaging and extractions from the devices themselves, which colloquially we have been referring to in court as quote-unquote raw data. That is generally not something that is in the state's possession. I have, in my career in our office, never received raw data from a phone extraction. I receive a Cellbrite download or an Axiom download for a device from the CFIU unit. I give it in discovery. That is not something we generally ever receive and or tender in discovery. There have been cases where a defense hires a forensic expert who makes a request to inspect or a request to look at the raw data or receive raw data for a device. The reason being, and I'll have Detective Padilla testify to this in a moment or explain to the court in a moment, the data from the phone has to be parsed so that it's readable. If they have an expert who wishes to parse the data themselves, that is why they would want to receive that raw data. The raw data is voluminous. It is very, very difficult to transfer. It is going to take a long time to transfer between devices. When they parse the data, the court should not be surprised, and their expert, I'm sure, would tell you the same thing. The parsed data they get is going to be different than the data we parsed because it's been 2 years since we parsed it. And because of the way Cellbrite and Axiom work and the way cell phones work, as iOS's update or Android software updates and Cellbrite updates its software over time, we are able to parse more data as we catch up to the technology of the phone. So I just want everyone to not be aware that that's going to happen, and that's normal and expected. However, their motion to me seems to be just a blanket, we want this raw data for every device in the case, including devices that in a state's estimation have little evidentiary value. The deceased victim's work computer, the deceased victim's laptop, some other items, and the computers contain an exponentially large amount of data, larger than the raw data you would get from a cell phone. So I will have Detective Padilla explain to the court the timeline and the procedure of what he's going to do, as well as to advise the court. And as it regards to Jared Bridegan's devices, the raw data is stored currently on a CFIU detective's hard drive. CFIU for JSO recently moved offices to a new location. During the move, part of his hard drive was damaged. Detective Padilla has been undergoing a data recovery procedure, and I'll let him kind of explain to the court how that's going, but that is going to, at least for the deceased victims' devices, that is going to be longer than 60 days to recover that data and give them the raw data from his computers. If they wish to parse the deceased victims' work computer data themselves, I mean, they're entitled to ask to inspect and do this, but it's not something we normally do in discovery. It is something if they are requesting and the court orders me to do it, we will do it, but it is going to take some time for those devices particularly.
All right, so I want to kind of hone in on the issues. Is that what the defense is requesting? Did you want this detective to do it, or were you all attempting to have your expert, because I recall it could be related to some other issue, but I recall you all saying that you were having an expert come in, making an appointment, that appointment was canceled. So explain to me exactly what you are requesting related to these devices.
Your Honor, it's my understanding that we want the raw data.
How? Do you want your expert, like you can make an appointment, inspect, and
Copy. I mean, I think that was the initial idea, was to copy the raw data.
All right, and so you don't necessarily want JSO to provide it, you want to be able to copy it.
If JSO wants to provide it, we'll take it. Or if they want to make it available to us, we'll copy it. I I don't know why Ms. Stifler says it's, quote, not in the state's possession. Obviously, if it's in the possession of the Secret Service or other agencies that worked along with the state to prosecute this, it's in the possession of the state and it's subject to inspection, copying, and otherwise discovery. So we've asked for it. That's what we want. If they want to copy it and provide it to us, that's fine. If they want to give us access to their CFI, I think part of the problem is it's on a CFI hard drive. My understanding is they don't want to give us, our expert, access to their computer system, so they need to put it on some other form of media for us to take it.
All right. Well, Detective, if you'll be sworn in.
One thing, Your Honor, just to clarify that. Their expert can't extract the devices himself. It's not like I can hand him the computer and have him extract it, because once you turn a device off and leave it off, the system is going to update it, and the data that we've extracted is going to be more complete than if you did another extraction. The data we extract, okay, well, I'll let him speak to it. But to copy this data, he's saying copy it. His expert can't just come and copy the data. It's going to take
Let me answer that.
36 hours.
All right. You raise your right hand and be sworn in.
Detective, do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you would please state your full name for the record.
Yeah, Detective James Padilla, but I go by my middle name, Shannon.
Okay. Detective, have you reviewed this list?
Briefly, yes. I was provided this on Friday.
Okay. Let's, do you understand what they're asking for?
Yes, and if I can just clarify a few issues, that would be we're all on the same.
Wait. I want to know the easy answers first.
I'm trying.
Okay, the easy answers from this list, what can be provided as quickly as you can?
Quickly is a relative term in regards to this.
Well, what is what can you provide?
I am currently not in possession of any of these items, so I first have to get it from whatever examiner provided this dump for them.
Wait a minute. Who?
There's multiple examiners that were involved in this case. I was not one of them.
All right.
I was brought in to help facilitate making sure all the data that was collected from all the examiners, one point of contact, so that the defense can have one response from us.
Okay.
That's been what I've been tasked to do. And to clarify, there are 3 states of information. First is the actual device that was being used, say a cell phone. Next, we're going to extract data off it. That would be what we call the raw data. And then there's the parsed decoded data that we would provide normally to the state. Our general practice is we do not provide the raw data because it's such a large data set. We usually parse, decode it, and provide that report to the state. We will provide the raw data when necessary. In this case, we're looking at I think somewhere around 19 devices. That's a large amount of data, and it's going to be very difficult. And to put into some kind of perspective, most of these are going to be roughly 1 terabyte to 2 terabytes worth of data, which is a large amount of data. 1 terabyte takes 4 to 6 hours to copy from point A to point B. I'm having to get this from whatever examiner provided it initially, which means they're going to take 4 to 6 hours to copy it to a device to give to me. I'm going to have to take 4 to 6 hours to move it to a device that I can work on it. And then I'm going to have to validate and verify that the data is the same as provided to me. And therefore, that's another 4 to 6 hours of processing and validation.
Wait a minute. So on this list, I'm counting 13, not 19. Where's that coming from?
That's just, like I said, roughly 19. I haven't counted.
So it's 13.
Yes.
And I understand that it would take some time. So what this court wants to avoid is that they are, I guess, scheduling this time with whatever expert, that it's not wasted, okay? So let's just, is one of them, I know that you want all, is one of them more probative to move you all forward? And you can have kind of a priority list of your work. Since, I don't like to look at things in this big, like, oh my gosh, this is too much, because that never gets anywhere. Because if you just stop, or if we don't prioritize, we're not moving. So if y'all had to prioritize this motion.
Judge, can I file something with the court then after
Yes.
today. I'm not prepared to answer that right now.
Okay.
And just for court and defense's information, and I had spoken with Ms. Medina about this, on their list, there are 2 categories at the end: not accessible, Apple MacBook Pro and Lacey external drive, and then another one, found in Potomac and not correlated to tenon, 4 devices. We have no ability, the non-accessible means that they are encrypted, so the data is, we can't decode it, so those are not accessible to us or to defense. So there is no ability for us to give any kind of discovery related to those items. Through no fault of our own, we're unable to, I guess, crack into them, I guess is the way I would phrase that. Found in Potomac and not correlated, there were 4 devices that we seized during a search warrant at the Potomac house. We were unable to correlate those 4 devices to any of our suspects or co-conspirators in this case. So
Were they downloaded?
No, ma'am. They're just in property, they're not downloaded. So that, again, there's no discovery relating to these items. They were not correlated to our search warrant. We had no probable cause to connect them to our suspects, so we have not downloaded them.
Okay.
Judge, if we could get a written response, I mean, that's, I think part of the problem is that this motion that Ms. Medina was filed the 31st of March, and this is the...
No, I get it.
Yeah.
So,
And Ms. Medina and I have been emailing about this. In fact, these categories, not accessible and found in Potomac, are based on the information I gave her regarding what I just put on the record. But I've been telling the court and telling defense I plan to file a written response. I just have not been prepared to do so until we discuss amongst each other. I'll discuss with my expert, discuss with my detective. After our discovery meeting, I should be able to file some written responses to these if we're not able to come to an accord.
So I guess maybe some of this confusion maybe came up that it got uploaded on this evidence.com. It was placed on some type of disclosure as an exhibit, but what detective we're trying to avoid as much as possible, right, is a moving target on
He's reviewed this motion. There's some indication here that there's a download user error because some of the folders are different sizes and cannot extract, which it could be there was a computer task occurring at the same time the download was happening that interrupted it. But he is verifying the data and hash valuing each of these devices so we can tell defense this device should be 184 gigabytes. If you have it, it's that size and you're opening it, that's the correct version.
Okay. So for example, let's just start with the first one, just so I have an understanding. Black iPhone. Were you able to associate that? Has it been down? It says no forensic images or extraction. So are you going to go through this list and say whether you had it extracted or whether there was a second search warrant?
Yes, the black iPhone 19 belongs to the deceased victim in this case. It was extracted and the data was parsed. They're requesting forensic images and extractions, which is the raw data. Raw data, unless you have a forensic machine, like a physical analyzer, on a hard drive, they could give it to me, I would never be able to open it and read it. I don't have the correct forensic equipment to parse and decode the data to make it readable.
Okay, hold on just one. Is that what y'all are requesting? It looks like you just don't have anything. It says that the Word document cannot be opened. I don't know what CRC stands for, but has an error. It just appears that they can't open it.
And Judge, that's my understanding as to what Ms. Medina was pointing out.
Right, not that, like...
And I think that's separate and distinct from getting the raw data from some of the devices that was being requested.
So many of these, they have the Cellbrite extraction, and I have disk.
What does CRC stand for, just so I know?
It's like a hash, but it's a validation check that a software does. I'm assuming that's a zip file or an archive file that when it was extracted, it failed its CRC check.
Oh, So maybe it's not working on y'all's end either.
I have not looked at the data yet. I'm still trying to gather all this data from all the examiners.
Okay.
But my task was to take all of the data from all of these devices and collate them together, verify that they all work, verify that this is all the true and accurate thing, and then so they can get a true copy in one dump. The biggest problem I have is one of the examiners, as she mentioned, his hardware failed. The majority of these items are on that piece of hardware. I'm actively trying to recover that data. I am about a week into the recovery process right now, and it continues to fail. So my hope is by the end of the week that I'll have access to that data. But that's the biggest challenge, is getting that data off that drive.
And that particular data relates mainly to the devices of the deceased victim in this case.
Okay.
But handing them, their expert and I have been in communication, Ms. Medina and I. My understanding is they want the raw data because they have a forensic expert who will be able to parse it. Otherwise, if I hand a defense attorney a hard drive with forensic imaging extraction raw data, I might as well be handing them a doorstop because you can't read it, you can't view it, you can't do anything with it.
I understand.
The physical analyzer.
I understand.
Something like that.
But what I'm looking at on their motion to compel is that what the detective just said, that these things have failed, they have no ability to even look at what detectives have. So why don't we...
Do we want to prioritize? So Gardner's motion to me is a request to provide raw data.
I will let them...
Motion is...
I'm going to let them talk about it. But to me, the raw data, I understand it's going to take some time. I don't know how long it would take to come up with just usable reports for attorneys to look at. It looks like 1, 2, and you're saying that hard drive got corrupted, and that's what these are on, and the devices don't.
So it's a RAID. It's 4 drives that work in conjunction as one drive, and there's a hardware component that makes them talk together. That hardware component failed, so the individual drives are not talking to each other, and the only way to get data off those drives is to make those 3 talk together. So the hardware has failed, and I guess in the transit or the move, it got damaged.
What about the device? It doesn't exist on the device anymore?
I don't know exactly what's on his hard drive.
No, I mean, like, so...
She's talking about re-extracting.
Yeah.
Just redoing the device. You can't do that?
JSO doesn't have any of these devices. This is all Jack's Beach, so they may or may not have the devices. I don't know the status of the evidence. Because when we got, so just to back up a little bit, when somebody submits something that's out of jurisdiction for JSO to us, say a cell phone, it's not our property. We're not got nothing to do with the case. We would have returned it back to the investigating agency. In this case, Jack's Beach.
Jack's Beach still has these devices in the past.
So maybe
that is possible. The problem is when you talk about a cell phone, it's running off of SQLite databases. As soon as you power that phone back up, data is going to move. Databases are going to purge data that was scheduled for purging, and it's going to have a lot of different data that we didn't have, 3 years ago when this was all done, or 4 years ago. So it's going to be different data, and it's going to create a whole host of other information if we do that.
Well, they're saying they don't have anything.
I know, and my hope is I can recover the data off this hard drive, and I will have all of the original data. But I won't know that until later this week when the process. I've gone 16 and a half hours so far of actual computer processing time of it rebuilding that RAID. So I haven't been to the office this morning, so it was running over the weekend. So I'm hoping when I get to the office this afternoon that at least phase 1, and I'm able to image all those drives to start the next phase, is to recover the data off it. So that's my goal, is to get that data. The majority of these items are on that hard drive, and that's the first challenge. The second thing is re-extracting all this data. You're talking 40 to 60 hours of work to download all these datas again, and that's actual time.
Okay. Well, I'll table it. I'll let y'all talk. You prioritize.
Yes, Judge.
In my mind, so obviously I'm familiar with re-downloading, the fact that Cellbrite updates, that it can get more information. If it is, when you all speak, maybe, to me it should be wherever y'all are with the discovery. Let's say, according to this, whatever was filed, they don't have anything. So saying that The extraction hasn't been received, so.
Well, the
if-
extraction refers to the raw data. They do have the Cellbrite reports because,
You do?
as Ms. Day noted on her motion, they have a lot of the Cellbrite reports, they're having different sizes of files. All these Cellbrite UFDR reports that are readable have been provided on evidence.com. For the deceased victim, I have CDs, discs. If they're missing that, that's news to me, and I can provide that this week. It's their motion, I'm reading it as forensic imaging and extraction, and that refers to the raw data. That to me was what they were missing, and that's kind of been my conversation with Ms. Medina, because Mr. Green, the only reason I'd ever provide this is if somebody had an expert, otherwise it's not useful information. This was what we were doing to get ready for that meeting with Mr. Green. So this was a list that she and I have been passing back and forth that she's picked.
Is that what y'all are looking for?
Judge, I can't answer that question.
Okay.
You know, I
All
have
right.
reason to think that Ms. Stifler
We'll
is
see
incorrect.
Thursday.
Yeah, so if that's the case, that's the case. I just know that there was a motion filed, and that's what we were looking for.
All right.
And just to clarify one thing, because if we're going to start down this road, the prioritization would be very helpful, because the bigger devices, some of the ones that are going to take longer, are computers. So if the deceased victim's work computer is a low priority to them, that is one that would take a long, long, long time. We can put it to the bottom of the list. I also need to know from Fernandez's team if they are requesting raw data, if they have an expert that's going to parse it, because I need to know if I need 2 copies of this down the line. Obviously, it'll take twice as long.
Okay, well, y'all can handle that offline, okay? I will get an order out. I did see the notice on the report, so I will enter an order allowing Mr. Gano to distribute his work.
Yes, Judge.
All right. 2 weeks. Two, maybe 3. Maybe the week of May 5th.
Yes, ma'am. I'm out all next week, so I would ask for 3 weeks so that I have time to coordinate. Bless you.
Sometime the week of May 5th.
Yes, Judge.
You all tell me.
If it's fine.
5th? Okay.
We could have the 6th or 7th.
Judge, I have a 10 o'clock federal court hearing on the 6th, so as long as you can get me out of here by 9:30.
7th? Really, Mr. Crody?
I'm available the 7th.
7th? Have you all talked about the trial date? It's set for October. We're not going to make it.
We've discussed the...
Mr. Rahi was not at the last court date, so
Right,
we discussed
so
the trial date. I think the defense was going to...
I'm just asking, did you all discuss it amongst yourselves, or do you want to wait until this May 7th date?
The state has discussed it amongst our team. We have not discussed it with defense yet.
Do you want to wait until May 7th?
That's fine, Judge. Do we want to strike the October dates at this point? I don't think anyone in this courtroom believes we're going to make it.
Let's strike it.
Thank you.
So I'm holding courtrooms. The clerk's office is, even what I'm trying to get y'all to do. Like Mr. Mizrahi, you weren't here, but my thought was we move it to 2026, and with thought into scheduling, thought into if we're going to have that number of jurors, right, and I want them working as simultaneously as they possibly can. And when you all are talking about, like, we're going through the discovery, right, that the state thinks about how you would do it. As much duplication as possible for the jurors. Obviously, physical evidence they could share it, but I want the juries working as simultaneously as they possibly can. So I want them overlapping. I want them, like, for example, like one gets closed down, one is closing, both are working. The defendants, if it becomes necessary in a penalty phase, as little downtime as the jurors can have.
Well, okay then. I guess we weren't meant to hear the end of that. Interesting. All right. I guess we weren't meant to hear that. All right. Hey, check this out. I should have played this at the beginning. If we're trying to stay in real time. But Barry, welcome in. You got me looking, and this is what I found.
The woman at the center.
You got me looking, and this is what I found. Hold on.
We are here.
They
who fake
the first time
represent
over their 2 children. Let's listen in on what happened to court earlier today.
All right, so here we go. You will definitely recognize this person.
We are here for arraignment in Shanna Gardner's case.
We would enter a plea of not guilty and amend discovery at this time.
All right. Would you like a formal reading of the indictment?
No, Your Honor, we would waive that.
Subsection F, the capital felony was committed for pecuniary gain. Subsection I, the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The State of Florida requests the defendant provide the State of Florida a statement of particulars listing the statutory and non-statutory mental mitigating circumstances that the defendant expects to establish through expert testimony. The names and addresses of those mental health experts
Are all Ms. Gardner's counsel capital case qualified?
We have 2 we have one that is for certain. I am as well. I'm not caught up on my CLE, but I plan to in the meantime, just as a backup. Mr. Brody will be serving as death qualified counsel for the purposes of moving forward.
What is the status of any discovery in this case?
Mr. Bias provided the email addresses of counsel and their paralegals. We will send a link for our electronic discovery today.
Okay. And from this point forward, because it is a joint indictment, I'm going to schedule all hearings with Mr. Fernandez from this point forward.
We plan on getting started immediately, depending on how much. I have no idea. My understanding is
There's about 7 terabytes of data.
Do you have an idea of the number of witnesses?
Over 100.
Then we will schedule this matter on December 1st, 9 a.m., and that will be for pretrial, and I will set the other cases accordingly.
He wants to hit the ground running. Well, earlier this year, the confessed gunman Henry Tenon pleaded guilty and agreed to testify against Gardner and her current husband, estranged husband, Mario Fernandez.
All right, Psychosaurus, no, I didn't hear that. If you heard that, good ears on you. I didn't hear that. And then, okay, so then we've been kind of kicking around. When's this going to start? And you guys were all correct. It is, it's been pushed to August. So let's check this out real quick, and then we'll get back to hearings. The only reason I'm playing this is this has happened. So we were in April 14th, and then we're going to September 19th. This news report came out July 31st. So let's check this out. So this is July 31st.
We now know the start date for the trial in the shooting death of a First Coast father of 4. It will be delayed until August of next year, August 2026. That's more than 4 years after Jared Bridegan was shot and killed in Jax Beach. And today the judge also decided the civil case against Bridegan's accused killers will not move forward until we know the outcome of the murder trial. Shanna Gardner and Mario Fernandez are both charged with first-degree murder and Bridegan's alleged 2022 murder for hire. Henry Tennant pleaded guilty to second-degree murder charges, but Bridegan's widow, Kirsten Bridegan, is also seeking $100,000 from Gardner, Fernandez, and Tennant for battery resulting in wrongful death. Kirsten Bridegan is seeking money to compensate for multiple things, including pain and suffering, loss of economic support, burial, and funeral expenses as well. The judge in the case said today she is considering bringing in as many as 500 potential jurors for the murder trial because of the high level of public interest in this case.
500. All right, so August 2026. All right, so that's that. All right, so we've got two more pretrials. This one's from September. So that news report was July 31st. So I couldn't find that that hearing. So this is from September 19th. September 19th. And then we have one final one from November 14th, and then we'll be done, and then we can go watch Courtney Clenny. So then we can get over to Courtney Clenny, because she had a hearing yesterday, and I definitely want to see that one. Definitely want to see that. Oh, and yeah, Shanna's really tall. Mario's really short. I'm not sure Jose what his height is, but Shanna is really tall.
May be seated. Morning, Your Honor.
Good morning. Good morning, everyone.
Morning.
Morning, Your Honor. Ms. Stifler.
Your Honor, Christina Stifler on behalf of the state on the cases of Mario Fernandez and Shanna Gardner, numbers 1 and 2 on the court's calendar.
Thank you. Good morning.
Good morning, Your Honor. Patrick Carodi, present with my client, Shanna Gardner.
Good morning, Your Honor. Jesse Dreiser, present with my client, Mr. Fernandez, along with Ms. Day, Frank Tassoni on Zoom, and James Hill on Zoom.
All right, thank you. Good morning.
Good morning.
And Your Honor, for the record, next of kin is present via Zoom for today's court date.
Okay, thank you for that. All right, we're here for a pretrial and a status, so.
Yes, ma'am. We've been conducting monthly discovery meetings as we advised the court we would be, the last being yesterday. We received the court's orders on the motions for protective order filed by both defense teams. And we have collectively, for both defense teams and myself, made redactions to the state's supplemental discovery exhibits based on the court's order. They're highlighted in orange so the clerk knows what needs to be redacted to comply with the court's order. And I've let Mr. Dreiser and Mr. Carodi review this, make additions, and we're all in agreement that these redactions encompass the court's order. So I'm filing state's 8th, 9th, 10th, 11th, and 12th supplemental discovery exhibits at this time.
Does the defense agree?
Yes, Your Honor. For the record, there are highlighted portions on those exhibits that we've agreed
Okay.
to be redacted.
Your Honor, for this hearing, may I remain seated? The microphone issue.
Yes, yes, I'm
Quite awkward.
absolutely. The dates listed on here, those are the dates of disclosure to the defense.
Yes, Your Honor. I was just holding off on filing until the court's ruling on their motions. So the dates on there were the dates that I provided, the discovery exhibits for either to defense or viewing to defense, and the items listed have been provided as of those dates listed on there. I know, but. Okay. I know you.
All right, so I've reviewed each one of the discovery exhibits, and I just want to confirm, state's ninth does not have any redactions. Y'all agree with that? Do you want to see it?
Sure.
Okay. I just want to make sure y'all agree, because that's the only one that does not have any highlighting or to the clerk. Okay. No, I don't. Thank you.
Then we were discussing, while you were reviewing those records, just kind of putting the clerk's office on notice that although it's highlighted now, someone from the clerk's office will black it out through their protocol. Is that,
yes.
We're all on the same page on that? Okay.
Right, Ms. Nelson? Okay. All right.
Okay. Your Honor, defense also is in receipt of the verified hash valued extractions and the raw data requested by defense counsel. Both teams received a hard drive from Detective Padilla with the Secret Service and Jacksonville Sheriff's Office Computer Forensics Unit of 2.13 terabytes, and I confirmed with them yesterday that's the amount of data they have. They have an itemized list so that their experts can compare the hash, and Detective Padilla confirmed for me that it should be 2.13 terabytes. So we're all in receipt of that digital evidence, and that was in response to the defense motion regarding duplicative devices. And once they've had the chance to review that, we can address it with the court if we need to. But that should have solved that issue. We do have depositions set October 10th and October 17th.
I did see that.
And I am working with defense on accepting service of subpoena for some of those witnesses.
And I'm assuming, I appreciate the cross-noticing from Ms. Gardner's case so that both sides are documenting like the work that you're doing. And there's one witness, I think, on the 17th that is North Carolina.
There's a few out of state. I've spoken with, some of them are family members of the deceased victim. Defense has advised they will allow out-of-state witnesses to appear via Zoom, and those witnesses have confirmed that they'll appear via Zoom.
Y'all agree with that?
Yes, and we thank the state for their assistance with those witnesses.
Okay, you don't have to stand up. Okay, it's probably equally as awkward. Yes.
And just because we agree for the purposes of these depositions and probably many, but I don't know that that's a global agreement at all times that out-of-state witnesses that we won't do in person.
That's fine. I specifically asked Mr. Crody and Ms. Day yesterday at our Zoom meeting, and they said they were fine for this round. Rather than all of us traveling out of state, they're fine with these particular witnesses being via Zoom.
That's correct, Your Honor.
Okay. Is there anything further?
One additional matter on scheduling, if we could just approach sidebar.
Sure. James. Thank you. Did you all want to come back to sidebar, or you have some kind of understanding?
Your Honor, we're going to speak offline. We're just requesting a little bit of time to go over some things. When we have a bit more time, I want some time to think about some of the things that both defense has suggested and the court has suggested in regards to scheduling. And we will reach out to Your Honor regarding our logistics meeting.
Okay. So, did the defense want to be heard at all? Okay. All right. So what I've done over the last few days is I've been going through the docket. It is this court's intent to honor that date that we have previously set. So in my mind, we need to start kind of using that time frame and then working backwards, making sure that we're all kind of getting to that point, because there will be a lot of resources and time spent on both sides. So I want to make sure that we are going to accomplish that date. So with that being said, and looking through the docket, I need the defense to kind of go through the motions that you have already filed and let me know whether you need a hearing on them or not. Okay, so some of them, I think Ms. Stifler referenced that this takes care of X motion. So the pending motions that this court has not entered an order on, I need by the next court date a decision by the defense, whether you want to call it up for hearing or whether you want to file a notice of withdrawing it. Okay, and if you do file either, if you would just indicate the docket line, because we're getting deep in the docket, so that I can get to it expeditiously. Next is that the state, I believe, on December 12th of 2024, you provided the court with a discovery exhibit documenting the depositions that went forward. And then I believe that documented up to the deposition notice of the defense up to your 11th. And so now you all are on your 20th. So what I'd like to do, I'm going to enter a case management order. So from this point forward, I would like for the parties to file notice with the court of the depositions that are accomplished. So on your notices, you have the list of names. It doesn't have to be anything like super formal, even if you all just want to put on the side, excused, whatever, and then file it so that we can just keep up to date, like not huge disclosures, but just kind of one after the other.
And I had intended to do so every 6 months or 10 notices. Do you want us to do it after every round of depots? I've been keeping track. I can file up and through where we are today.
Okay.
How often does the court want us after every round?
Well, what I intend to do is I'm going to basically come up with an Excel spreadsheet. I'm going to put all the witnesses in the spreadsheet. I'm going to cross-reference what has been filed so far, And, the rules allow the lawyers not to take depositions of someone or for whatever reason. And so if you don't intend, I believe, especially in capital cases, it needs to be documented. So in some way. So if you don't intend to do it, so it doesn't appear, later down the line that it was an afterthought or something that was overlooked, there is documentation for whatever. So you can just say, excused, don't intend to reschedule. Some are excused to reschedule, things of that nature. Okay?
If the state doesn't have an objection, and I am fairly certain it would be no issue to send it to the state to look at first, if it would help the court, we have that Excel
Oh, you do?
spreadsheet already made, and we could give it.
Well, thank you, because
So I'll run that, unless they have an objection now, I'll send it over to them, and then we'll send it to you, and then you can work off of that, whatever.
I appreciate it.
Sure.
Because to get a good sense of like where y'all are at, to me, it helps. Like, for example, however many witnesses y'all have, if y'all have been kind of talking offline about like, okay, we don't really need that person, it appears to me that if they're listed in a way like that, then that's something that could cause significant, time. So then I believe it was probably like mid 2024 when I wanted to make sure, and are y'all having these conversations, I guess is my question, that y'all are communicating about, what witnesses may have information that's pertinent to the penalty phase? Are y'all doing that? Because the state's position, this is my recollection, the state's position was, well, we're relying on a lot of these witnesses for the information related to potential penalty. So, which is fine. I just want to make sure that when y'all are, because there is significant time being put into the depositions, that information is also being covered / like notified to the defense so that they're able to ask whatever questions they need to that may not come in the guilt, but potentially would come in the penalty. But I'm hoping that y'all are having those conversations. But number two is that if there are witnesses that are solely for the penalty phase, I need the state to disclose them in that manner.
Yes, Your Honor. At this time, I can't think of any that would solely be testifying in the penalty phase other than victim impact. And many of those are listed as guilt phase witnesses as well, but I will let defense counsel, particularly before our next round of depositions, some of those witnesses will be for both portions, both victim impact and guilt phase. I'm not looking towards victim. I don't think that's necessarily an adversarial process. I think that's a constitutional right by the victim. What I'm referring to are information or witnesses that potentially the defense could, or the state would be relying on for penalty purposes only. Let's say, for example, not purposes only, but has information that might be relevant to penalty. Yes.
Either for aggravation or mitigation.
Yes, ma'am.
Okay.
This time, the state's not aware of any witnesses that are solely for penalty phase aggravation. Due to the nature of the aggravators, they interweave or intersect with our guilt phase evidence.
Okay. So to that extent, I want to make sure that that is being put forward to the defense so that y'all have time to process / question. Now, on the defense side, I know that there have been some of the, capital motions that have been filed. Do you have a time frame in which, do you think that you can have them, the remainder, kind of filed by the beginning of the year?
Yes, Your Honor.
Okay. Mr. Dreiser?
Yes, Your Honor. We believe that we could abide by that timeline.
Okay. What time frame?
I thought you suggested by the beginning of the year.
Well, that can mean many things. How do
January 1st is what I took that as.
Okay. I'm going to do mid-January. Do you all have a sense of when the information related to the discovery on the guilt?
I'm sorry, on that point, it's our position, and I'm sure Mr. Crody would agree, is some of these death penalty motions are fluid. That may be a deadline for the ones that we know we're going to file, but I hope that's not a deadline in the sense that as case law emerges, as new issues emerge, I mean, the death penalty in Florida is, and across the country, is in flux with the number of people and the unanimity issues. So we would file motions that we thought we needed to file at any point up to the trial.
Sure. I'm not going to preclude you from filing them, but like to the extent, so some of them generally I will take under advisement, especially the ones that are related to like jury selection and things like that. But the ones that, you know that you're going to file for whatever reason, but if there is something new and emerging, I would not preclude you. I'm just trying to get to a point where we can handle the bulk / majority of them, and I'll handle whatever motion you want. But we've been going along. I think that there have been four or five filed so far. So if you all could kind of get what you want or need to preserve for whatever purpose, if you could have that filed by the first of the year, so I can schedule at least some time to address it, and whether you want a hearing on it.
Yes, ma'am. We're
Okay.
on the same page.
Or if you want the court to rule on the papers. Okay?
Yes, ma'am.
Do y'all have an idea of when you think the discovery guilt phase would kind of be concluding?
In terms of depositions,
Yes.
I'll leave that to the defense to answer that question. I don't know what depots they intend to take.
Maybe I'll take that up at the next court date.
Yeah.
So this is, all right, so let's say the hard stop is August, okay? Right? You all, I would assume, would want to work back from that date for kind of, this is what we have. This is what the state has. This is what the defense has. And we can get to a place where y'all feel like you have gotten the majority of the information. That's what I want. At the next court date, I want to have some kind of idea, all right? And I'm thinking, around April-ish. So 4 months out, this is the evidence, okay? So then from the evidence, we can work as far as, are there evidentiary motions? Are there, is there litigation that needs to occur related to any issues that have now arisen? But 120 days out from the date, that is August, that everybody has a good picture of kind of what's on, on both sides. Then also, I believe that if there is any mental mitigation or anything like that, that needs to come at or around that time, okay? So.
You're saying in April, Judge?
Yeah, around that time.
I mean, but the rules don't require it, I think, until 20 days prior to trial. So I can't tell the court that I'm gonna be ready in April. We typically dispose it a month before trial.
Your mitigation?
Yeah, our mental mitigation.
Oh, I strike that. You're right. Mitigation. I'm assuming the state would want to talk to some people.
Right, no, I agree.
Okay.
Yeah, we'll disclose witnesses that we intend.
Around April. You think that's unrealistic?
I don't, no, but discovery's ongoing, right?
Right.
But as far as a statement of particulars for mental mitigation.
No, I said strike that, Mr. Crody.
No, I'm with you.
I'm on. I'm moving on.
Yeah.
I said the wrong thing. So I'm saying at around that time, because otherwise you need more time.
As soon as we have confirmed that we will intend to call someone during the penalty phase, our intent is to disclose the person. And we will have at least a list of people by April. Whether or not that's our complete list, and I can't assure the court.
I don't want to, I want to, as much as y'all possibly can,
I
okay?
understand the court's intent.
Right?
Yes, sir.
Because I don't, at the last minute, I don't want everything to go away because no one has time or something is disclosed at the last minute or there's a discovery issue or Richardson that completely, I mean, I want to handle as much as I can pre-trial so that when we get to that point, we kind of know what it is. Everybody has everything that they need so that we can move. It's going to be already hard enough, okay? So I don't want to have side issues like that take a lot of time, okay? So to the extent, and y'all have been working well together, I just want to tell you what my intent is. This is a heavy lift on all parties, all parts, right? And so I just want to make sure that we are planning and moving towards that date, like that is the date, okay? So to the extent that you can, because I don't think that I've seen any disclosures by the defense.
No, there have been, Judge.
There have?
Yes, sir.
Okay, all right, then I'll look closer then. The state hasn't scheduled any depositions though.
Most of the disclosures related to the Arthur hearing, so some of those witnesses have testified, and we have received information from defense counsel that we're investigating, so.
All right.
Mr. Fernandez has not made any disclosures to the penalty.
Okay. When do y'all want to come back?
November or December, Judge?
Alan Mizrahi next, because it was mentioned before.
Yes.
Alan Mizrahi on behalf of the state. I just wanted to clarify something the court said about our disclosure about penalty phase witnesses, and making sure that their information is known to defense and depositions can be taken of them. We're obviously doing that. The court also said something about mitigation, and I just want to make sure that the court wasn't putting a burden on us to disclose mitigation. We don't know whether it exists. We're under a duty under Brady to disclose anything that's exculpatory.
Right, no,
Okay.
I'm not.
Okay.
I was, maybe I'm not being artful. So what I'm really saying is that if there is impeaching information or something along those lines of information that would relate to the penalty phase, that it's disclosed in some way to the defense, that y'all are having those kind of conversations. And I know just generally in litigation and in depositions, like you're not doing it necessarily formally, but you know that there is something and then it's alerted and the defense is able to question about it. That's all I'm saying. I'm not a burden, just that you all are communicating / doing those things is what I was just bringing up. Is that occurring?
Yes, Judge.
Okay. That's all I was saying. So no burden. I'm not making up new rules. I just want to make sure that you all are having those types of conversations. The depositions, the discovery, that's y'all's business. My business is making sure that we are moving towards the date that was set. Okay?
Yes, ma'am. Defense and state are in constant communication.
Great. So the 17th. Will y'all be in like the holiday week? I don't intend to have a trial, so I can hear y'all pretty much any day that week.
The Thanksgiving week?
No.
Oh, I'm sorry.
November 10th is Veterans Day, I believe.
Yes, ma'am. I'm out the 10th, but I'm available 12th, 13th, or 14th.
When Mr. Bias filed a notice of unavailability, when,
I think it was October 15th through 29th.
Your Honor, he's not available October 15th to the 26th, so he should be available in November.
okay, thank you. Is that Ms. Medina?
Yes, sorry, Your Honor.
All right, thank you.
Wednesday, the 12th is fine, and Friday, the 14th is fine.
Mr. Carodi, Ms. Medina.
Judge, I've got a federal trial scheduled for the trial term of November, but they don't tell you what week it is. And
Is it here?
yes, Judge.
Okay.
Presumably,
Could someone
I
from,
don't even know if it's going to go, so I would
Okay.
say schedule it.
could someone from the firm cover
Someone can find someone to cover.
if you do?
Yes, Judge.
Is there anyone else that wants to be heard about the date? I'm going to set the 14th.
What's the date, Your Honor? I couldn't.
I'm sorry, November 14th.
14, let me see.
And
Yeah, that should be fine.
I know affirmatively I'm going to be out of town on the 14th. I'm sorry.
You will?
I will.
Okay. Do you want to check with your colleagues then?
Well, Ms. Medina is my colleague, so
Well, I know that,
she
but
says that she can cover.
Okay.
Then you can.
Ms. Medina, she can barely hear you, Mr. Carodi, I'm pretty sure. Ms. Medina,
Yes.
are you able, Mr. Carodi said he's not available.
On the 14th?
Correct.
Yeah, I believe one of us would be able to cover.
Okay, so I'll use that date. Thank you.
Thank you.
All right, so the next court date will be November 14th, and that'll be at 9 a.m., and that's for pretrial. All right, thank you all for your time and your work on this case.
Thank you, Your Honor.
Thank you.
We're going to be open for a minute, because I'm going to meet my client in the conference.
Yes.
I'm going to meet with Mark.
Good to see you.
All right, so that does it for that one. And you heard Judge. You heard Judge London Kite say, "We'll see you next on November 14th." So let's get to November 14th. This will be our final one, and then we're going to go over to Courtney Clenny. So this will be our final pretrial hearing for Shanna and Mario. So let us get over here. Here, Barry, this is for you. There's all kinds of recessed lighting there for you, or or ceiling lighting. All right, let's cue it up. Nope. Well, hi. Wow, when's Judge come in? This is going to be shorter than I thought. I thought it was 20 minutes, and it's going to be a lot shorter than that. Here she is. Okay, here we go.
Brian, so for his GRP sensation, I'm just trying to decide.
Thank you. Good morning. Good morning. All right, Ms. Stifler.
Morning, Your Honor.
Good morning.
Christina Stifler on behalf of the state, numbers 5 and 6 on the court's calendar, Fernandez-Saldana and Gardner.
Good morning, Your Honor. Gardner is present before me, and Michelle Medina from Bias Law Firm is on.
Thank you. Good morning.
Good morning, Your Honor. Jesse Dreiser here on behalf of Mr. Fernandez, along with Ms. Day, Mr. Tassoni, and Mr. Hill, and our clients present. May I remain seated for the rest of the hearing?
Yes, thank you. Good morning. All right, if the parties could please give me an update.
Your Honor, since our last court date, we have conducted 2 full rounds of depositions. I think other than excusing 1 witness and the state relisting 2, we had 100% attendance rate. We do have depositions set November 21st and December 5th, and we're asking for a pass date to December 8th following those depositions.
Okay. And does the defense agree?
Yes, Your Honor.
Yes, Your Honor.
And I appreciate the parties filing the motion so that I guess we can get organized. My plan is to put out a case management order, by the first of the year. So I appreciate y'all getting that work done between the court dates as well. So everyone's available on that next date?
Yes, ma'am.
December 8th?
Yes, Your Honor.
Okay. So in both Mr. Fernandez and Ms. Gardner's cases, we will return back to court on December 8th, and that's 9 a.m. for a pretrial. And that case will be handled first. That's a jury selection day for me. Okay?
Yes, Your Honor.
All right. Thank you all very much.
Thank you.
Thank you, Judge. Have a good weekend.
Thank you. You too.
I told her. Let's keep those.
Well, that's that. We don't have the December 8th one, unfortunately. Let me see if December 8th. We don't have that one. Yeah. Unfortunately, we don't have that one. Meh. All right. All right, we can start Courtney sooner. We were going to start at when were we going to start Courtney? Oh gosh, I hope it wasn't at 3. When was Courtney going to start? Okay, we were going to start Courtney at 3. I'm going to change that. Let's start Courtney a little earlier. Let's go with 3. No, let's go with 3:35. That'll just give me a few minutes to get things together. All right, we're going to change Courtney to 3:35. So, all right, you guys. So that kind of wraps it up with Shanna Gardner and Mario Fernandez-Saldana. I always remember that. I always just want to say Mario Fernandez, but it's Mario Fernandez-Saldana. And we got most of their pretrial hearings in. There was a few here and there that either they weren't streamed or we just couldn't find them. But I think the overall theme of that was the state is having issues handing over. Well, they're not having issues. They're handing over evidence and discovery to the defense, and the defense is like, well, we're only getting half of it, or we're not able to access evidence.com, or their file structure is different, and then state saying, well, it's user error. It's just a bunch of finger pointing going on, and everybody's just saying, kicking sand in each other's faces pretty much. So it seems like they've kind of got it sorted out. But yeah, so now it's August. It's August 3rd, I guess. August 3rd, I think, is when it's scheduled to start. We'll see. So much for a speedy trial, right? So, all right, you guys, that's a wrap. That's a wrap on Shanna and Mario. So we'll cover it. I mean, we definitely want to cover it. This is going to be a big one for us, for sure. All right, Alice, thank you. Oh, look at little Roger. What are you doing up there? Dude, what are you doing? Goofball. Do you guys see him? Look at him up there. You see the way he's hanging? He's hanging like that. Dude, what are you doing? He's so silly. All right, you guys. Appreciate you joining me today. Thank you to our mods. You guys did a fantastic job. Thank you to Erin. She put all these videos together. I think I just threw in 1 or 2 there at the last minute. But with that, we will say goodbye to you. Please join us, Courtney Clenny. Let me do a redirect. Has Erin put a redirect on? Let me see. I'm pretty sure she has, but oh no, okay, let me do a redirect. All right, redirect to Courtney Clenny. All right, so you just have to sit tight, and we will portal you over to Courtney Clenny. Yeah, just hanging around, right? Oh, and he's gone. Oh, he's playing with the tie, the shades tie. Psychosaurus Rex. I'm so glad that they're hanging out in there again. There was like a period of like a month where they didn't touch it. Now they're back. They're back to hanging out up there. So that's cool. All right, you guys. Again, thank you for joining us. Thank you to our mods, and thank you to Aaron. Please join us over at Courtney Clenny. It's about an hour and a half, so it's not too long. We'll be done by, let's see, 3/4. Yeah, we'll be done by like 5 o'clock. Perfect for a Friday. All right, we'll see you in a bit.